Hello, may I have your lordship's leave to move an urgent motion on Wednesday? Hello, a very needy family. The wife of the petitioner got service on 8th November 2013. Well, he expired immediately after 10 years on 10th of November 2023. Well, on October or on 4th, well, the petitioner went to the DI office. Well, a file is ready regarding pensionary benefit. But they told that it will take time because an objection was raised. Nothing objection, only 10 years service. Well, the family, the daughter of the petitioner is a student of 3 years.
The department.
Well, let it appear on Wednesday. Well, otherwise, well, I am serving all the respondents. Well, the family is two square meal. He is not in a position to maintain.
Today is Friday. File it in the department. Give the number. It will appear
on
as urgent motion on Wednesday.
I get full word.
Department.
Yes, yes.
To mention these two matters, my lord. These two matters is appearing in the list of Progoto versus earlier determination. But the matter was taken up thereafter, my lord. Since the other side was not present, his lordship directed this matter, verbally directed the court officer that put this matter on 4th November. So, my lord, I have heard your lordship directed your lordship's court officer that since if there is no order for coming in the list as a so matter will not be as per CD item. So, my lord, this is one is higher scale FA and then one is widow, my lord, CPF to GPF, my lord, the pension. My lord, so my lord, let it be on, since it was not appearing in court, let it be on 10th, it will be up.
10th, Monday it will not be possible. Let us see where the file is. Wednesday it will appear.
My lord,
notice.
My lord, may I be permitted to mention one assigned matter? My lord, there is a writ petition along with an anticipatory bail application which has been assigned before your lordship, and your lordship has passed an interim order protecting the petitioner till 11th. Now the matter was returnable 4th, it did not appear. If it can appear, my lord, before 11th, any day.
Check up.
11th assigned matter, it Monday, but you check up. 11 तारीख of the interim order.
Gratuity interest matter. Mention it on Monday. Don't give any slips today.
My lord, me lord, to mention a matter pertaining to upper primary para teachers. This is pertaining to 2016 selection process. There were 10% vacancies were earmarked for them. My lord, the matter was substantially heard by the coordinate bench. My lord,
I'll release it. Give the number.
all the matters. My lord.
I have heard some of the petitioners.
Bunch of 2025 matters. My lord.
All right.
It was last taken up on 11th. It was supposed to be listed on 6th November.
All right, then I'll release it if it is substantially heard. Give the numbers. To be mentioned, Thagwe.
My lord, I'm mentioning for transfer on medical grounds.
Not today, madam. Come on Monday.
I need to mention to contempt application, my lord, that is arising.
No, next week. Next week.
My lord, it is of circuit bench, Jalpaiguri matters, my lord. Kindly.
Jalpaiguri matter. All right, give.
My lord, I'd like to mention one urgent matter regarding the petitioners were.
Don't read. Say what is it.
My lord, the School Service Commission did not give an opportunity for the petitioners to update their application form as EWS category in the for second SLSC 2025.
But then the form was filled up long back. The examination is also over. What you want now?
For filling up the.
How can it be done?
Updating the application.
How can it be done? Where is the scope? Yes.
But the petitioner is not being allowed to resume duty since 2021, my lord. This matter is pending. It's a motion matter of 23, my lord.
Yes.
For inclusion and upgradation, my lord.
No, inclusion and upgradation, not today.
Yesterday, number 25, my lord, WPL 4701, which related to the teaching experience matter, the emotional benefit matter. My lord, our mistake, you also have pointed out, my lord, the petitioner, she was a waitlisted candidate, not an impaneled candidate. Because if the order has not been signed by lord,
give the number once. I'll check up whether it has been, because none of the orders have been put up in the server today. The files are there.
Yes, the order has not been server.
That I know. Give the number. I'll check up once.
Well,
Eta jodi show
matter, my lord. Application matter, my lord.
Call the list, please. We decide with. Mr. Shaktipada Jana or anybody from his chamber? কালকে ডিসপ্লে হয়েছে তো দেখলাম। Mr. Jana, are you still there?
Appeal was dismissed, SLP was dismissed, now the petitioner has received all this.
Please come. Learned advocate for the petitioner submits that the order passed by the court has been complied with. The order passed by the Honorable Supreme Court on 15th January 2025 in
Yes.
case number লিখে দেবেন তো be retained with the records. The contempt application stands disposed of.
I appear on behalf of review applicant, my lord. My lord, I appear for the response. Pleadings in the matter stood completed. So I'm allowed to place my case, my lord.
I file my affidavit.
Yes. Affidavit to the review.
The application for stay.
Stay
They have filed.
in the review.
Yes, my lord.
There is an analogous
my
app.
lord.
GA2.
GA1 was already disposed of. It's for condonation, my lord.
All right.
GA2 is my stay application. My lord, it can be heard altogether, my lord. The review application can be disposed of all.
Yes, yes.
My lord, this is a matter, my lord, where the petitioner before your lordship is the widow of a deceased employee who was working with Bamal Lorry. But following death of her husband, my lord, what has happened, my lord, she has applied for gratuity and other ancillary benefits. Now there is a miscalculation so far as the gratuity portion is concerned. Now in the gratuity portion, we have demanded that there is an entitlement of rupees 8 lakhs odd. Whereas depending on the HR manual, which has been retrospectively amended as per the version of Baman Lorry, I have entitled with 2 lakhs. So your lordship was pleased to dismiss. My lord, following dismissal, what has come up, if your lordship please to come to the, there is a notification at page 158 of the stay petition. This document was not available at the time of filing of the writ petition. My lord, this document has been, my lord, payment of, if your lordship has got
Yes, page 1.
payment of family pension, death gratuity, and other dues to the family on the death of the government service during service regarding the undersigned is directed to say that the COVID-19 pandemic. So it was specifically, my lord, on the ground, the person, the deceased employee who has passed away due to COVID, my lord. This has been specifically made applicable on that count itself. So this document was not made available before the review applicant or the petition at the time when the writ petition was heard. So this is the only point on which I am assailing this review application, my lord. Now, my lord, so far as my learned friend is concerned, there is a point of maintainability which has been taken in this regard.
Yes, yes.
Well, the point of maintainability, there are 3 different scores which I have understood upon going through their opposition. My lord, the first one is the review application has been filed by a different set of advocate who was not engaged at the time of writ petition. My lord, that is not permissible. And in this regard, my lord, there is a judgment of 1975 Supreme Court, if I may rely on. My lord, this also says the same thing, that it is not permissible, and this has been followed after also till this
What
day.
is not permissible?
My lord, filing by a different set of advocates. Now, reasoning is important, my lord, why it is not permissible. Why the change of counsel at the stage of review is not permissible? Because it talks about the scope where the matter cannot be re-argued on the same score. My lord, my contention is that Order 47 permits that if a document which was inadvertently not been brought into the record, which ought to have given a different perspective or outcome of the matter at the time of hearing, then a review is maintainable. I am not here, or the newly engaged counsel is not here, my lord, to re-argue the matter on the same thing. So this has to be the point, whether a counsel can be engaged at a stage of review, it has to be read with the parameter of Order 47, Rule 1. This is my first answer to the point of maintainability. Second, my lord, they have stated they are denying that there is the person who has passed away, the employee, the husband of the petitioner, has not died due to COVID, my lord. In that regard, my lord, if your lordship be pleased to take my affidavit in reply for once. The very last annexure, page 12.
This is the memorandum of review. Affidavit of accomplishment. Yes, page 12.
Page 12, the last annexure, my lord.
Yes.
My lord, this is a certificate issued on my saying, my lord. It was subsequent, and if your lordship be pleased to peruse the date at the top right hand, 12/8/2025. This was by the Union Territory of Dadar, Nagar and Havli, Daman and Diu, my lord. The husband of the petitioner was posted at Silvassa under Bamal Lorry. My lord, kindly see the content, name of beneficiary, Akansha Agarwal, that is the petitioner or the review applicant, address such and such. My lord, there is a name of scheme, COVID-19 ex gratia assistant to the next kin of the deceased person. Now, 50,000 was granted. This was exclusively for the purpose that the husband of the petitioner passed away due to COVID. My lord, the third is, my lord, they are saying that the notification which I intend to rely on, which was not brought to record of your lordship's court at the time of hearing, that was not applicable so far as Bamal Lorry is concerned. In that regard, if I request your lordship to please revisit that page 158 of my stay petition, the very next page, page 159, at the bottom and left portion, my lord, 2, kindly see secretary of all ministries, departments, CMD, and point number 8, CMDs of all public sector pension disbursing banks. So, well, that covers my case, that this notification squarely covers my case, and I will be similarly footed. Now, so far as the notification is concerned, well, kindly come to page 161. There's a tabular statement.
What does this notification say regarding pension?
Well, not only pension, that's I'm coming. Well, page 161 under B, death gratuity.
Yes.
Well, under serial number Roman 3, 5 years or more, but less than 11 years. 12 time of the emolument. Well, maximum there is a slab, there is a cap. Maximum amount of death gratuity will be rupees 20 lakhs.
How many years did he serve?
My lord, somewhat of more than 5 years, my lord.
So he'll come within the slab 5 to 11?
5 to 11. He ought to have, my lord. Order of your lordship, my lord, is at page 151. If I may take your lordship to that order, my lord. The petitioner for paragraph 2, at page 151. The petitioner prays for grant of gratuity payable to her husband on 15th of June 2021. She was communicated that she would be eligible to receive gratuity rupees 8,55,000.
So your claim is regarding gratuity?
Gratuity only. My lord, I'm limiting my claim towards gratuity only because the other parts has not been argued at the time of writ petition. I cannot re-argue this matter, my lord. My lord, so far as the scope of review is concerned, if I may please to rely on recent Supreme Court 2025, my lord. My lord, page 6 of this judgment 2025 regarding the scope of review. What?
Yes.
My lord, paragraph 14 onward. Lord, in summing up precedents on the point, the judgment may not be understood as though we are putting an old spin on a classic. The court notes that there is no infirmity or illegality in entertaining the review petition. However, the approach to the error pointed out warrants a review to the precedents on the point. Now, my lord, from 15.1 onwards, the Supreme Court has taken consideration all those judgments which has been passed in respect of a review when a review can be made maintainable, my lord.
Yes.
Lord, one more thing, my lord, the order of your lordship. There are two important factors, my lord. If your lordship be pleased to come to page 154, which is a part of the order itself. my lord, page 154, paragraph 13 of the order, my lord. The order in the writ petition.
Yes.
The company in the affidavit of opposition has mentioned that the husband of the petitioner was appointed with an appointment letter issued in December 2014, and on the date of his appointment, the gratuity payable on such and such is 15 days emoluments, such and such, and the aforesaid rule was approved by the Commissioner of Income Tax with effect from 16th of July 2013. So they have made out a case that there is an amendment prior to joining of the husband of the petitioner. And in furtherance of that amendment, which has been already accepted by the income tax department, there is a change so far as the payable of gratuity is concerned.
How much has been paid to you?
My lord, 2 lakh something, my lord, 2 lakh.
Alright, and how much according to you will be payable?
My lord, 78,000 is my lastly drawing emoluments, my lord. It would be multiplied by 7 years, my lord. 2014 I have joined. 2021 I have died, my lord. My husband has died, my lord. So it will be into 7 years as per the notification which has been made specifically applicable so far as COVID death is concerned.
What does the figure come to around?
Lord,
5 lakh something?
I'll just make a calculation, my lord.
Yes, then. Hmm.
5,46,000.
Yes.
My lord, this is my limited argument, my lord.
My lord, before take your lordship to the merit, my lord, there are certain issues with regard to the maintainability. My lord, what my learned friend has submitted, that's proceeded on the basis that there is a discovery of a new document. But the application and the review petition proceeded on the basis that that is an error apparent, my lord. My lord, they have pleaded in paragraph 9 onwards in the
Today, error apparent has not been uttered even for a single time. It is the case that has been made out today is that something new has been discovered.
Yes. What they are saying, my lord, in the application as well in the repetition, that the court has erred in not considering this circular.
No, that is not proper because this was never.
This was
before the
never
court.
the case, my lord. Second, my lord, the another of the which my learned friend has agreed, my lord. My one of the point was that a state change of counsel, my lord, cannot file a review even after taking consent, my lord. I am carrying, my lord, judgment of the Honorable Supreme Court, my lord, as well as of this Honorable Court, my lord, which says, my lord, this is the first judgment, which is of Supreme Court 1997, 9 Supreme Court cases, 736, my lord. This process practice has been replicated, my lord. My lord, you see, my lord, para 1 and 2 is the spectacle that new practice be unbecoming of not worthy on conclusive of to the profession is cropping up. Mr. Manipuram, advocate on record, has filed vakalatnama for the petitioner respondent when the special leave petition was filed after the matter was disposed of. Mr. Sadansat has filed a petition for review that was also dismissed by the court on Sadansat. Yet another advocate has now been engaged to file the present application styled as Sagar has now come up application for clarification on specious plea that the order is not clear and unambiguous. When an appeal special leave petition is dismissed, and except in rare case where the so my lord is dismissed, except in rare cases where error of law is fact on apparent on the record, no review can be filed. That too by the learned advocate on record who neither appeared nor was a party to the main case. It is slurry to the note that the court spends valuable time in deciding a case. Review petition is not and should not be an attempt to a pre-hearing of the matter again on merit. Unfortunately, it has become a recent time a practice.
Yes, then.
Milord, this has also been, Milord, taken care of by our court, Milord, Justice Tandon in 2018, Milord. He has also relied on this judgment and, Milord, dismissed the review petition, which was, Milord, filed upstream. Milord, this is reported in 2018 SCC Online, Calcutta, Milord, paragraph 10, Milord.
What will be your submission with regard to page 158, a document which was
Milord,
not there?
that is in our affidavit, Milord, we have taken stand, Milord, that is not applicable to us.
Why is it not applicable?
It was, Milord, issued by the ministry for applicable for the departments and, Milord, the government. For that, he has to be a government servant. It is applicable to the central government servant, Milord. Bamalori is a PSU. The last which he is relying on, that too, Milord, that was given because all these pensions and coming from
No, you are not the bank, but then public sector undertaking, will you not?
PSU and pension for Milord, PSU, Milord, there are public sector undertaking which are banks.
Yes,
These are issued to the banks so that
that
this,
is different. Bank
yes,
is different.
this doesn't, Milord, apply to me. Because for that, my lord, he has to be a central government servant.
Oh, I understand.
Yes.
But then all public sector,
My lord, it's for who? CMDs of all public sector / pension disbursing bank.
so
So,
it
my
is
lord,
not applicable
no,
to.
my lord, it is applicable for a central government employee. If my lord, Bamalori is a company under the Ministry of.
Followed.
So, my lord, this could not be taken into consideration, my lord.
My lord, kindly see so far as this proposal.
Applicability of page 158.
My lord, paragraph 7 in the same page, my lord. All ministries, stroke departments,
Yes.
and their attached subordinate offices will submit a monthly statement on such and such. So it has been
It
made,
is
my lord,
neither the ministry nor the department.
my lord, it's a PSU under the ministry itself.
No,
Baman
that
Lorry,
way you cannot extend this.
my lord, I am not extending this notification is applicable, my lord. There is mere statement that this has not been made applicable, my lord. My lord, I being an individual, I cannot go on hunting whether this particular notification has
The
been made
authority says it is not applicable and they have not applied it in case of
my
anybody.
lord, because my lord, there's a disclosure by way of an affidavit so far as the gratuity disbursal of gratuity is concerned. Persons died since 2013. Now in that particular list, my lord, there is now of the person who has died due to COVID, exclusively due to COVID. So the applicability so far as the other employees are concerned, my lord, that has not been brought into record, neither I am aware of, my lord. Lord, the case has been made out in a general manner. I am carving out an exception so far as COVID death is concerned.
Show me that this has been made applicable in any other PSUs like.
Lord, in that
Sorry.
even, my lord, I humbly seek some time so that I can come
Very
back.
well, come ready. Please come. The affidavit in opposition and the reply thereto in connection with GA2 of 2025 filed in court today is taken on record. So, the petitioner / applicant places reliance on the notification dated 3rd June 2021, annexure E at page 158 of the aforesaid application, and submits that the same is applicable in respect of the respondents. Stop. It has been submitted that the aforesaid document was neither available nor within the knowledge of the applicant petitioner at the time of filing the writ petition, and accordingly the said document could not be placed at the time of hearing of the writ petition. Stop. Prayer has been made to review the order passed upon placing reliance of the said document. Stop. Learned advocate for the petitioner relies upon several precedents in support of his prayer that the review petition will be maintainable. Stop. Learned advocate representing the respondents.
No, I'm responding 2 only.
Actually, respondent number 2 denies and opposes the allegation and claim of the petitioner. Stop. It has been submitted that the review application will not be maintainable. Stop. Reliance on precedents has been laid by the learned advocate. Stop. It has also been submitted that the notification relied upon dated 3rd June 2021 will not be applicable in respect of the respondent number 2. Stop. Learned advocate representing the petitioner applicant seeks time to revert with further instruction and documents. How much time do you want?
2 to 3 weeks, because the only resort I'll be
Very
having to make RTA.
On such prayer, release the matter for further consideration on 12th January. No, not 12th, 13th of January.
But I have filed my affidavit in
It has been recorded.
Greatly.
নামটা নিয়ে ডিবেটে
I appeal for the petition. I can come up at our instance, my lord. The
Your name
bench-
has been wrongly recorded.
But everybody's name have.
Everybody's name. Give the slip.
Yes, ma'am. We all had appeared on that day.
সুব্রত বাবু, আপনি
So very good.
আজকে ডেটটা লিখে রাখুন, তা নাহলে
पूरा पूरा दोनों पूरा
এই তো দিলাম আর কি, হ্যাঁ এই তো নিয়ে নিচ্ছি।
this is huh.
This is another facet of prior experience. Again, I have my applications can free.
I'm praying for short passover, my lord. I am led by my lord, Learned Mr. Shami Ahmed, my lord. He is arguing on courtroom number 1, my lord. Kindly, my lord, short pass.
I also have, my lord, the same prayer, my lord, because same matter is going on in courtroom number 1, my lord.
Well,
Kindly pass it to
this is fundamentally, there is a difference because lordship is already hearing the prior teaching experience. Now, this is questioning at what time. There are two matters. প্রথমটা directly. So if the first matter, they say if it is a prior teaching experience, lordship probably would be hearing it along with the others.
12th.
In the meantime, my lord, I have been able to, because yesterday I placed one judgment, I've been able to get hold of some other judgments directly on that.
All right. 2, the petitioner seeks a passover.
Passover. I have no difficulty. I can wait.
Short
We can continue with 3.
Yes.
All right.
My lord, item number 3, my lord, my challenge is twofold challenge. First, my lord, I am not challenging whether 10 marks are to be can be given or not. I say 10 marks may be given. I have no problem. My
Who
issue
are
is-
you? Who are you?
I am a candidate, fresh candidate who have applied in the
Second SLST.
second SLST for 9, 10, 11. My lord, my challenge is you can give 10 marks. There is no problem with that. The competence of the legislature has decided. My point is, when can these 10 marks be given? After interview or before interview? First. Second point, my lord, this prior teaching experience can be given to anybody except those candidates who have lost their job because of the illegalities in the selection process, and the Supreme Court has declared the selection process null and void. This is my second point, and my first point is
That
With-
means anybody who participated in the 2016 recruitment process is not eligible.
not eligible. This is my second point. First
Alright.
point is when can these 10
No,
marks?
yes, this I followed.
My
Yes.
lord, only for that, my lord, if your lordship kindly comes,
Page number 27.
page 27.
Who is opposing item 3?
My lord,
I'm praying for a passover in item 2 and 3, my lord.
I am
Oh,
appealing-
you are praying for
Well, I
passport.
filed an applications because
In which matter? 2 or 3?
both the matters.
Both.
Because I am appearing for the untainted candidates who were serving and they were honest, but ultimately because of the circumstances, they lost their job and now, my lord, they have participated.
All right.
Now, if prior teaching experience, whatever lordship decides,
My lord,
if they go against me, if it goes against me, I would be affected. For that reason, I have filed an application.
my lord, my
Can free.
my lord, we have also filed. I'm led by Mr. Mitro.
All right. All right. Same thing. What is the number of your application? Can 2?
Can 3.
Can 3 is here, but then 1 and 2, yours must be 1? This is 1.
But can 1 has not been served upon us.
Whatever, 1 and
Yeah.
2, the files are not here.
Can 1 has not been served upon us. Can 2 and 3 has been served.
Dekho button.
Proceed,
File
my lord,
issue.
they will reply or your lordship.
Lord,
will
kindly
reply.
pass it over, my lord. and keeps it up, my lord, at 11:30 or 12, my lord.
Let them start. So
We'll have
Take
to.
down notes.
Yes.
You take down notes, let him come. One batch is on 12th.
Yes.
Let me
Look,
just.
this is a separate matter
That-
regarding interpretation of
Yes, that's the
two
other
rules, my lord.
that is being raised today, not the same point.
But it's not the same point.
Yes, yes.
Comes to page
এক মিনিট যাও, বুলাকে লাও।
1 আর 2 কে আনান।
ঠিক আছে।
18 নম্বর তো এটাই কোড। Yes,
And at page 27 of my request, all petitions are coming.
no, this is a different point that has been raised. This is not there.
This is not there, but
So this is a point is different. Connected with that point, not connected with the SLST, because there may be so many matters with that point. And if it appears that it is to be heard on 12th, I'll place it on 12th.
if the 10 months have been expired,
Yes,
person of going can be given.
right. Right. Yes.
Well, when is fundamentally different point, no doubt.
Absolutely.
When
When the
it
main issue-
survives, it's fundamentally different.
Provided it survives.
Survive. Yes, yes.
Yes,
Definition.
right.
My lord, page 27 of my. This is the rules, my lord. Rule 2 and within the relevant portion, my lord, rule 2K, page 27. What is an interview list? My lord, may I read?
Hmm.
Interview list in respect of SLST state level selection test means in case of vacancies in the post of assistant teacher, a list of candidates prepared by the Central Commission to be called on merit for oral interview and lecture demonstration category wise on the basis of preliminary merit score, which is that is score for written examination and TET. TET is not applicable for us written examination. And academic score in the ratio of 1:1.6. So, my lord, this is the interview list, written examination score and academic score in the ratio of 1:6. Now,
No,
my
no,
lord,
it is not 1:6. It is 1.6 is to
1
So it's a different.
1:1.6.
merit list in respect of SLST state level selection test means in case of post for list of candidates for vacancy wise on the basis of merit, which shall mean suitable to what has been stated in rule 2(1)A marks obtained in oral interview, lecture demonstration and prior teaching experience. So, my lord, my case is prior teaching experience should be awarded at the time of preparation of the final merit panel, considering the marks of written score, interview score, and lecture demonstration, and thereafter prior teaching, not at the stage of interview for calling a candidate for interview.
What is the marks, full marks of the examination
My lord, 100. My lord,
and the
for-
breakup?
yes, my lord, for that schedule to page 36.
36.
Lord, this is schedule to A.
Written examination 60. Educational qualification is 10. 70. Prior teaching 10. 80. Oral 10. 90. Lecture demonstration 100 marks.
So, my lord, I say this written examination marks and academic score will be considered for calling a candidate for interview. Thereafter, after the interview, at the time of preparation of the final merit list, the prior teaching experience marks.
All right, see, today 2 applications are not on record. First. Second, the written examination marks have not been declared. So we'll post this after.
No difficulty.
Right.
12, only thing, my lord, why I am apprehending. Today the results will be published in all probabilities.
All right.
If the results are being published, calculating these 10 marks, then my lord, entire thing will be
They have not yet calculated written examine. Today, the result, if it is published, it is only for the written examination.
No problem, let that assurance be given.
No, they
Because-
can. How can he give assurance?
No, my lord, what I am telling on lordship, the candidates directly went to the commission. The commission says the result that will be published calculating the written examination marks, academic score and prior teaching experience.
That is true. That's true. He is right because that's the law requires.
The result that will be published today.
Yes.
But this is not the result. The wording is not the result. It is
Read
under-
marks.
No, it's a interview list.
All right. So if
Interview
it is
list should be comprised of what things are there under 2K. Dr. May kindly have a look at that.
yes,
Kindly see. Interview list in respect of the SLST means in case of vacancies in the post of assistant teacher, a list of candidates prepared by the Central Commission to be called, all these parts not that much important, on merit for oral interview and lecture demonstration category wise. Now this is the important. On the basis of preliminary merit score. Kindly pause for 1 minute. What is statutory preliminary merit score? That has been defined within the bracket. That is score from written test and or TET. Now here and or because for up to upper primary, they get a teacher eligibility test. So that is kind of, I would say, educational, how to teach. They get that marks. So that's come under TET. And for us, it's a written test. Kindly read this: written test and academic score. Now, what is the academic score? Kindly come to, there is a defined under schedule 2. Well, under schedule, may I just say and thereafter show. There are 3 things: A, B, C. A equals to 9, 10. B equals to 11, 12. C equals to upper primary, which is completely different because then central government, NCT, all others comes. Now we here come under A and B. Kindly come A and B. Under A, there is a bucket of the academics. Under 2, this academics has 2 components. Component number 1, what is course in the educational institutions, and component number 2 is prior teaching experience. Therefore, the interview list, which has to be on the basis of 1.6:1. That means if there are 100 vacancies, they will call 160%. That's the ratio. That has to be on the basis of statutory prescription. Now, interesting part is what possibly my learned friend might like to show is that under 2K, after 2K, there is a definition is of merit list. Now, this is one rule, caters to all the categories. Now, if I put 3 categories, 9, 10, 11, 12, upper primary. For upper primary, it is completely different. For them, they get it last. Why? Maybe the logic is they get the TET, unlike we don't get it. So for us, that is 9, 10 and 11, 12, under the bucket of the academics, prior teaching experience comes. So, this is and no, of course, he has not finished. Just to give, in case lordship finds that in case there is a, because my learned friend might like to show the definitions, in case your lordship finds that there is a kind of any conflicting view in any way, kindly take a look at definition rule 2, because everywhere, my lord, this is a very fundamental that all definitions are, well, I would not use my own words, it's there in the rule itself. 2.1. In the rules, unless the context otherwise requires. So all definitions are contextual.
My lord, I am appearing for the SSC. We have to make the interpretation, not the candidates first.
No, Mr. Bandyopadhyay, we suffered a lot. We lost our job.
We know that, but I have to make my suffered a lot. You have to make an application or not. Allow us. With this, not that. Don't. Let's serially. Let's go by serially.
Mr. Bandyopadhyay, nobody is shutting you out. You
No, I
stand
understand,
and
but-
I'm going to hear you.
But I understand, but not
Making
this.
submission, let him make his submission.
About our conditions also. We
Yes,
were
yes, you
working-
make your submission. I'll hear the commission also. It's
Yes,
not that
yes.
the commission will not be heard.
Well, the very core principle of if there is a conflict of little bit of divergence between the definition clause and the direct controlling clause. Controlling clause is the schedule itself, schedule 2 itself. In that case, the principle of unless otherwise request has to be taken into consideration. Now, what is the little bit of conflict? Little bit of conflict, Lordship may see it. Actually, not a conflict, it's a superficial conflict. That 2K talks about the interview list, clear cut. And for 9, 10, 11, 12, it clearly mentions that the preliminary merit score means two components, academic score and the written test. That's all. Now, what is the academic score for that, my lord? That schedule 2 under the bucket of the academics. Here the word there is here academic score. Academic is an adjective. But thereafter in the schedule 2, they have used the academics, which is in plural, which is the bucket. Under the bucket, they have put the, my lord, the prior teaching there itself. Now, my learned friend might like to show the definition, next definition of merit list that is in conflict. But that's, my lord, it's a superficial, that there is no conflict. Merit list simply defines two things. There is basically two definitions. Kindly have a look at merit list. Merit list in respect of the SLST, state level selection test, means, this is the first meaning. In case of posts, a list of candidates prepared category wise. Now, this is the first. And second, on the basis of merit, now which shall mean. So now this part is actually not defining merit list. This part is on the basis of merit means what? Shall mean in addition to what has been stated in rule 2 1K, marks obtained in oral interview, lecture demonstrations, prior teaching experience, and shall. So here prior teaching experience is there. But for upper primary, can you have a look schedule 2C. So for C, they get it 5 marks because they get TET marks. We don't get it. It is not. No, I'm trying to say that rulemaking authority recognized that situations are different. For 9, 10, they have made for academics under 2 pillars, the qualifications and the prior teaching experience. And that is in sync with the rule. He is not questioning the virus of it. I'm trying to say that. He is saying that by way of an interpretation itself, that they should get it. I say the schedule doesn't say so. But that's my preliminary submissions. And there are judgments by the Honorable Supreme Court that even for shortlisting, prior weightage, that can be done. It's a very recent judgment.
Can I make my submissions?
No, the petitioner has not
Yes,
even
this is different.
proceeded. Let him place his case.
Then why Mr. Dhar was started to submit?
It was
too worried. I mean,
it was.
What to worried?
It's all right. It's all right. I'll
Mr.
hear
Dhar,
it.
don't pass that stuff comment. Do not try to hijack everyone's case.
No, I'm.
My lord, here he is, they are making this submission, and in the Supreme Court, they are saying this act is bad. This is the
Yes,
whole
please,
problem
petitioner.
of them.
Petitioner.
My case
Contradictory.
your lordship has seen the rule and as well as definition rule and the schedule. Well, the intention of legislature in any legislature cannot be to cause injustice to one group and justice to another. My lord, the whole intention of providing prior teaching experience, my lord, that has also been stated by the defendant is the object is to get better teacher to teach the students. This is the only possible, my lord, reason for introducing prior teaching experience. Now, my lord, this prior teaching experience should not be awarded in a manner so as to cause injustice to other candidates who do not have them. Because, my lord, previously in the 2007 recruitment,
This batch of or this writ petition has been filed by batch of candidates who are absolute freshers. Yes.
my lord, previously in 2007 there was in recruitment rules in for SSC, my lord, there was a prior teaching experience, but a separate percentage of seats, 10% of total seats were reserved for these in-service candidates to avail the benefit of practicing experience and like that nature. So, my lord, there was no injustice. Now, it has to be construed, my lord, harmoniously, definition clause and the schedule. Firstly, my lord, the definition clause very rightly stated that when prior teaching experience is to be given so that it does not cause any prejudice to any fresh candidate. Now, my lord, take a situation. A fresh candidate out of 60 scored 55 and a in-service candidate score, my lord, 44, 46. Now, with this teaching experience, he get a call for interview and this candidate even securing more marks, my lord, in the written examination does not. That is why taking this into consideration, my lord, the legislature thought it fit that this prior teaching experience is only for the object of getting a good quality teacher, nothing else. That marks has to be given at the time of preparation of final panel, not at the time of calling a candidate for interview, because that will cause injustice. That is why, my lord, 2L specifically.
It will cause injustice if it is at the interview stage and not at the final merit list stage. It will be injustice at any stage if it is given.
Injustice at any given stage, because it creates at the screening level, it creates a advantage to a group of class among a class.
Yesterday, this is what the issue that was placed by Mr. Bhattacharya.
Yes, my lord, that is one issue. I say even if these 10 marks can be given, take a situation, your lordship affirms that no, these 10 marks can be given for the object of getting a better teacher. Now the question will come, when will these 10 marks be given so as to mitigate the injustice that will be caused to the fresh candidates? That is the, my lord, also I must say, my lord, the rule also provides that no injustice is caused to any fresh candidate. That is why these 10 marks are to be given at the time of preparation of the final panel. And my lord, your lordship knows, if your lordship kindly comes to schedule 2.
Yes.
Page 36, my lord. Academics, it is only a heading, my lord, but it's specifically subhead. Academic is one heading. My lord, 2. Academic is one heading. Practicing experience is another heading. It's not that under academics, it is practicing experience. Under the column 2, there are 2 heads, academics and practicing experience. It's not that under academic, it is practicing experience.
I think factually, this is just place it. I think factually.
My lord, may I? My lord, one, if your lordship is A, written examination, Weimar mark 60, then 2 academics.
Yes.
My lord, then after academics, it's being practice, completely different. And practicing experience, my lord, has no relation, with the academics.
See, one thing,
Yes.
in this schedule 2, academics
Yes.
has been described under 2 heads, A and B. But in the upper primary, see,
Yes.
academic score is 10 separate,
Clearly
TET
different.
weightage 40.
Yes, my
So
lord.
they have tried to create some type of distinction
Yes.
by mentioning sub-clauses.
Because, my lord, in upper primary, first, there is nothing like written examination and prior teaching.
A prior teaching experience, 5 marks have been reserved.
For upper primary.
Yes.
But for TET, my lord, for written examination.
That is separate.
That is completely separate.
40 marks, that is separate.
Separate.
Yes.
What I am on in schedule 2, my lord, under 2 academic, there is A is educational qualification, B is prior teaching. That under academic, it's only educational qualification. Prior teaching experience is a completely different thing. And my lord, this rule.
If 2 consists of A, then 2 will consist of B also.
2 is considered B, but the prior teaching experience does not include academics, my lord. That is why under 2 educational qualification, prior teaching. And my lord, it has to be read in consonance with rule 2L. My lord, if your lordship once again for my satisfaction comes.
Yes, yes, merit list you've placed.
My lord, this is my first point. This is my first point. My lord, my second point is, your lordship has already seen the judgment passed by the Supreme Court. If your lordship kindly comes to page 131.
Petition. Petition is 130.
Petition is 130. My lord, 2 paragraphs I will read for you. Paragraph 45 and paragraph 76. The last question relates to the relief and whether it requires any modification. we find
Where are you reading, please?
page 131, paragraph 45.
Yes,
That void point.
yes, yes.
And the last question relates to belief and whether it requires any modification. We find no valid ground or reason to interfere with the direction of the High Court that the services of the tainted candidates where appointed must be terminated and they should be required to refund any salary. This part tainted candidates for the time being is not in question because
Nobody is
No,
raising this issue.
according to me, my lord, if your lordship has rightly called for the list, why? If your lordship goes through in details, Supreme Court has defined who are the tainted candidates. OMR mismatch, there is out of
Whatever, we are not going into that.
For the present,
Yes, present we are not going.
my lord, paragraph 46. For
Hmm.
candidates not specifically found to be tainted,
Hmm.
the entire selection process has been rightly declared null and void. My lord, I stop here for a moment. When a selection process has been declared null and void, everything which has flown from that selection process is void ab initio, is null and void. Nothing can be gained from that selection process which has been declared null and void.
All right.
Declared null and void due to the egregious violations of the anticipalities which violated Article 14 and 16 of the Constitution. As such, the appointment of these candidates are cancelled. However, candidates who are already employed need not be. Here I am not
placing. All
Right,
right.
my lord. So when a selection process, it's not only the appointments, my lord. Selection process, there is a difference between selection process and appointments. Once a selection process has been declared null and void, my lord, there is no scope of giving any benefit from that selection process.
Yes.
My lord, and that is why, my lord, these 2016 candidates who have lost their job because of the declaration of the selection process as null and void, they are not entitled to any sort of benefit. This is my first point. Second, if your lordship kindly sees, for candidates not found to be specifically tainted, are they not found to be specifically tainted? That they have to establish before your lordship first. Why I say this before your lordship? Because, my lord, this says not specifically.
Is the list published by the commission on the website?
There is something. A list has been published.
Is it there in the website?
Yes, my lord. Yes.
All right. So anybody
No,
can.
my lord, there is a
No.
Show me that my name is there.
a list has been published by the commission. But, my lord, your lordship knows who are tainted has been defined by the Supreme Court. Weimar mismatch, after expiry of panel and out of panel. This list only contains candidates who have Weimar mismatch and out of panel. Candidates who have been appointed after expiry of panel. That is stated in paragraph 31. My lord, kindly come.
Where is the list available?
My lord, in the website that does not contain the name
Hey,
of
Shailesh,
candidates appointed.
please find out that list. Yes.
Mr. My lord, if your lordship
You have a
kindly
copy?
come to paragraph 31.
Let me see once.
My lord, paragraph 31 of the my petition one.
31. No, this at least I did not get it, so I'm not aware.
No.
Very well. I am not aware. Let me just see what is there. Paragraph 31.
Paragraph 31, my lord, of the writ. Page 125.
আমাদের একটা ওয়াইফাই তে খুললে হবে
Paragraph 31 of the judgment.
The judgment.
Yes.
Page 1, may I read? When WBSSC has also tried to justify extension of the term of span, as noted above, the time period of 1 year specified in Rule 21 for the destruction of Weimar-sheet coincides with the time period specified for the validity of the panel. There is no doubt that counseling process and appointments made to the post of assistant teacher for classes 9, 10 and 11, 12 were made after expiry of the panel. This is an illegal and contrary to the rules. Reliance on the orders of judgments of High Court in stray cases of rank jumping where the High Court directed to appoint candidates after expiry and validity of the panel would not have any significant impact. The court at that stage was not concerned and aware of the illegalities in the appointment procedure, and that not specifically examining the question of appointment after expiry of the panel. So, the Supreme Court has clearly stated appointment made after expiry of the panel, counseling and appointments made after expiry of the panel is illegal. So that those candidates who have been appointed after expiry of panel and appointments made thereafter is illegal. So they cannot be
The
considered.
panel that has been published,
No, that's
does it
initial.
contain this one, the list that has
Does
been
not
published?
contain the name of any of the candidates who have been appointed after expiry of the panel. And I say this, my lord, with responsibility, with the addition that even a single candidate found after expiry of the panel, your lordship will dismiss me with exemplary cause for misleading this honorable court.
Well, I think my learned friend is going to completely.
Lord, can I make submissions?
No, sir. I'll hear the commission later on. Yes.
My lord, so
This. What is this?
We are sending it for a print. We had it yesterday.
Okay.
my lord, whatever be the list, I say this with responsibility. No, even a single candidate's name is featuring in that list. I have checked it personally. After expiry of panel, no candidate's name is there. So even for admitting there who are appearing before your lordship that they are not found to be tainted, they have to show that they have been appointed within the time period of the validity of the panel and not after expiry of the panel. Well, these are my 2 points. And
before the commission,
All right.
before the commission will reply to this submission, may I add whatever points I have so that they can reply in comprehensive?
Is it the same thing?
Item 2, my lord.
Yes, yes. Item 2. The
Same argument, 2-3 additional points.
all right. What is the number? আচ্ছা কি দেখুন। Yes, item 2. আসেনি? When did you file it? Yesterday, so it's not here.
My lord, I have only received can 1 and can 3 probably, and no can I have.
Well, I have served everyone, so
All applications to be circulated. Otherwise, nobody should be taken by surprise. What is the addition? দেখি 2 নম্বরে ফাইলটা একটু দিন না। Yes, yes.
Yesterday I have seen the entire argument on YouTube. So I'll not repeat whatever submitted yesterday also.
But yesterday's point was different.
Not really. One of the point is with me in my writ petition.
This one.
In yes, item 2.
Yesterday, the virus of the 10 marks, whether it all it can be given
That is
or
one
not
of the
was
point I
issue.
have taken.
All right. Barring that, what is the other point?
Yes.
Today, another point is taken as to what stage the 10 mark is to be
It is,
allotted.
one of the point in my petition.
What is the other point?
Now, to support the second contention, if you see, kindly take some the definition clause once, K and L, to decide at what stage.
Yes. Where is it in your petition?
In page 80.
80. Yes.
Now, K is the interview list. Means, in case of vacancies in the post of assistant teacher, a list of candidates prepared by the Central Commission to be called on merit for oral interview and lecture demonstration, category-wise on the basis, then preliminary merit score, that is, score from the written test and or TET for upper primary and academic score. Therefore, for preparation of interview list, they have to prepare it based on academic score, academic, not S. This is singular number, academic score. And then ratio. To find out But whether teaching experience can be added prior to interview can be ascertained from the next definition, merit list. Because this experience marks cannot be given 2 times, before interview and after interview. It has to be given either before interview or after interview. Now, merit list means, in case of post, a list of candidates prepared category wise on the basis of merit, which shall mean in addition to what? This is important. In addition to what has been stated in 2(1)(k), the interview list. Therefore, what has been given in the interview list, in addition to that, marks obtained in oral interview, lecture demonstration, and prior teaching experience. Therefore, prior teaching experience must be in addition to what has been given in 2(1)(k). Therefore, there is no scope for giving prior teaching experience before interview.
All right.
This is one. Otherwise, they'll have to give 2 times. That is an absurd idea. Then rightly point out, so far upper primary is concerned, they have given the specific provision that they will give after. Now other parties, challenge has been thrown yesterday, so far awarding prior teaching experience of 10 marks. But I have prepared a list, rather kindly see the vacancy notified. This is for class 9-10. Vacancies were 1375. So these are the number of person appointed in 16. So all of them will get 10 marks. Then 16, 11, 12, 164. Now kindly take some 20, 25, 11, 12, 390 in 11, 12. And vacancy 9-10 is 2988. Yesterday, Mr. Bhattacharya argued that class within class, that is one part. I am not on that. Kindly see, they have invited application from all, including 16 candidates, all freshers. Now, if they award these 10 marks to the candidates having experience, then this experience of 9-10 is made applicable for 11-12 also, then there is nobody from the freshers who will get appointed, because this vacancy is only 390. And these 10 marks of secondary experience of a teacher in secondary education is applicable for senior secondary also. Therefore, there will be nobody in the senior secondary having no experience will get a chance to be appointed. So for senior secondary school, because 10 marks is the difference. Therefore, this is absolutely irrational, particularly when you are inviting application from all freshers. Now, kindly take up once again the distribution of marks at page rather schedule 2, page 89. Why it is irrational? For one more reason.
Yes.
At this point, I have argued, in addition to that, whether prior teaching experience of secondary education can at all be given for senior secondary, because 2 different classes. Now, schedule 2 is the written examination, 60 marks. Then academic, percentage wise marks will be awarded. Then teaching experience Now, I kindly see Schedule 2, Clause A. Selection to the post of assistant teacher for class 9-10 shall be made on the basis of marks obtained in the written examination, educational qualification, prior teaching experience, oral interview, and then lecture demonstration. Not what is lecture demonstration? And for lecture demonstration, Malat, kindly see the marks 10. In lecture demonstration, they will ascertain who is the best experienced teacher can demonstrate his performance.
Is lecture demonstration defined anywhere?
Not really.
All right.
Not really. Basically, it's a demo class of a teacher that they can explain. Now, a person having teaching experience is getting 10 marks. Again, he will be given 10 marks in addition for demonstration of teaching. Whether that can be rational. And whether this again creates a class within class. And whether they can segregate those who are teaching in a private college, private school, because in terms of RT Act, school has been defined, and that includes private school also.
I was wondering why this challenge has not yet
Yes,
come.
yes.
Maybe there are challenges, I do not know, because I have not got one. Central has come, but not private.
Yes. But what I
Oh, maybe. I have not yet
and
gone through it.
state of West Bengal is recognizing all schools, and they are supposed to maintain standard of education in all schools similarly. Therefore, they cannot segregate one school with the other. But how can they decide that they will give 10 marks for the teachers who are serving in a government
All right,
school?
that is not the issue over here, so I'll
That
not.
is one of the issue.
You have raised that issue?
Yes, yes.
But you are not from, are you from any private school?
Not really.
Are you a
But
fresher?
I am challenging a provision.
You are challenging it whole hog. I understand, but then are you a fresher or are you?
I'm a fresher. At least I have not pleaded that I am a teacher in a private school. I have not pleaded that.
You've not pleaded, and you have not appeared in the earlier examination also.
No, that
2016, you have not appeared. You are a fresh candidate. All right.
But this is oh yes. Yes, 12 experience to bollam je 12 provisionটা দেখো oh টুকটা দেখো but I is pressing that to demonstrate that for senior secondary is the same qualification they are seeking blood. That is at page yes. At page 90 the senior secondary লেখা আছে yes at page 90 milad
Yes.
after clause B prior teaching experience of 10 marks the line has been added at secondary level in a government or government aided or government sponsored school calculated on the basis of 2 marks each service in a substantive post. This is secondary and senior secondary. Yes, yes, yes. I'm sorry. This is for senior secondary. Even for senior secondary, they are taking experience of secondary education. And this will prejudice that chart I have handed over. Now, so far, other argument, Mr. Dashgupta has argued at length, the reason behind setting aside the entire selection process was that the court could not ascertain who are tainted and who are not. If they can today come with this solution that they have ascertained that these people are tainted, then my submission would be the others. The rest should be restored their service.
No, that is a different issue.
No,
Supreme
that's
Court is
not
there.
different. But if it is not, then till today they could not ascertain Who are the rest candidates could not be
all
asserted.
right, all right.
That's all, my lord.
You always have a turn, sir.
Oh, one more. One more thing, the application.
Oh, God has made submission. And the government is still doing submission.
Yes, the government is there, the commission is there,
Then
the private parties are there, all are there.
should I make my?
No, you make your submission.
If the Bandabandha can be there, allow me. You know, on the subject, what have to do? So, really to-
You take the microphone so that Mr. Bandyopadhyay can hear what you are submitting.
We might have checked. Oh, sorry, yes, no. Argued on tangent. That Mr. Shamin has argued that the rule is irrational. Void. Therefore, if it is void, no question of giving any marks. Today, and that is matter is fixed on 12.
Yes.
Should the matter be argued twice? Is that the court's intention? We can argue on the irrationality. Rationality. The court argued twice, very well argued twice. The clients, if the clients can bear the traffic.
Yes, I was
if
just.
the clients can bear the traffic.
I resisted myself
Bear the traffic. Yes.
because all are unemployed. So think of the taxation upon the candidates.
Not, not that,
Whatever you submitted yesterday, that can be noted over here also.
that must have been gone down the drains by now.
Not at all.
Not
It's all there.
This is one point. I'll come to the irrational point again. Next point is null and void. Supreme Court said null and void. Therefore, no benefit can be taken.
Just tell me on this issue, what has been raised today is the stage at which this 10 marks can be given.
Yes. Mm.
First. Second, the new point has come whether it can be given only to the state-aided sponsored schools, state government schools,
Yes.
and why not to the private ones?
Yes.
And then
That on the affecting
calculation
validity of the rule. No.
Yes.
Let's have one by one.
Yes.
Argument of Mr. Dasgupta has been on the basis. Clearly say the rule is valid.
Yes. That
So,
is one stage.
That if the rule is valid, then at what stage number
10
point
marks
will-
is to be
that's
given.
right.
And today the new issue challenging the virus
Hmm.
is that if the 10 marks is added to those candidates who got a chance earlier,
Hmm.
then the new ones will be prejudiced.
Very good. That is on the question validity of the
Yes,
rule.
yes.
Very good.
Validity issue. If you want to reply on the 12th, I can hear you.
Yes.
Because it has been argued today for the first time. If you want to reply today, it's all right. If you want to reply on 12th, I'll hear you on 12th.
Certainly will
All
accept,
right,
yeah.
all right, no issues.
Now, may I deal with the then? And this null and void, everything should be. No benefit
No,
can
that
be given.
see, argued yesterday also, that you can argue on 12th.
No. I don't adopt Mr. Dhos argument on that.
No, not adopting. Mr. Dasgupta, he submitted that it is null and void.
Yes.
Yesterday also the same thing was submitted.
Therefore, no benefit can be given, isn't
Yes,
it?
yes.
Now, may I start with that point?
Today or
Okay.
12th?
Why arguments are going on so in tangent?
Yes.
Can you see the Supreme Court order?
Yes.
Are they saying Supreme Court order is wrong? And my lord will sit in appeal over Supreme Court order and say order is wrong. Is that the argument? I want to know. At what stage our High Court has come down to? See the order of Supreme Court? Conclusion. এটা Supreme Court এর order annex করেছে ওরা। See, this right. It is really page 131.
Yes, 131.
139. See the Supreme Court order.
Oh, in that Rahul and
See the conclusion. Null and void, no benefit can be given. No benefit can be given to the tainted candidates. Paragraph 45. You can make a distinction in respect of tainted candidates, untainted candidates. See, or candidates not specifically found to be tainted, entire selection process has been rightly declared null and void due to egregious violation of the illegalities which violated Article 14-16. As such, appointments of those candidates are cancelled as such. Although they are not liable, they have not committed fraud. But because of some fraud committed by somebody else, they are being suffering, made to suffer. So, now next line. However, candidates who were already employed need not be asked to refund or this is benefit given. Supreme Court is giving benefit or not? See, candidates who were already employed need not be asked to refund or restitute any payment made to them. Is a wrong order? Wrong order.
Payment is not the issue, so do not raise this.
Not the issue. That benefit is being given by Supreme Court to the untainted candidates, although the process was null and void.
All right.
Being given, then argument, why the argument that no benefit can be given?
All right.
No, can you read on? If and what further rights are being given, benefit. However, the services will be terminated. Well, is any payment made to them? However, the service will be terminated. Service will terminate. But they have served for so many years or for a period, and they have taught. That taught is what they taught, what the teachers teach students, that is not null and void. They are working for and receiving benefit. Then the Supreme Court said, employed should not be asked to why they are not asked to refund the payments as the tainted candidates have been if the process void. Why? Supreme Court passing a wrong order.
All right. Next.
No. But can you see this argument must make?
All right. I have heard it.
Furthermore, no candidate can be appointed once then. Now we see another paragraph.
Yes.
Next paragraph, kindly see. No.
Please sit.
Paragraph
Please sit.
49. 3 million. Here's another benefit. That this disabled candidates is mentioned in the previous paragraph will be allowed to participate in the first selection process if required with age name. Similarly, other candidates who are not specifically tainted will also be eligible to participate with appropriate age relaxation. Further benefits are given by Supreme Court to untainted candidates. Supreme Court making a distinction between tainted and untainted candidates. And benefits are being given to the tainted candidates, although the selection process is null and void. And the argument is being, our High Court argument is made that if in selection process is null and void, no benefit can be given. Although they have stared on the face of it, Supreme Court has given benefit.
All right, then.
This argument, may I go into this? The process may be null and void, but the employment is something else, contract or employment. If under a contract or employment, the employer has taken some benefit and some benefit has been given, the benefit is to be restored. If a contract becomes void, benefit received already restored. I'm not going to principle, I don't argue. I said this argument not open for my learned friend to argue in High Court to invite stricture from Supreme Court.
All right.
When Supreme Court has actually given the benefit to them. And whether under this benefit you are appearing in the next election test. Now, next point is that at what stage?
Yes.
Mark. My Lord, my humble submission is this. If my Lord's attention has been drawn to definition clause, is it?
Yes.
My Lord, attention has been drawn to definition clause and the schedule,
Yes.
not to substantive part of the rules.
All right.
Not to substantive part of the rules. But in case of any ambiguity in the rules, substantive part has to be seen.
Yes, please show
And
me.
that's, can you see rule 11? Or can you before that some other rule? Yes, yes. After the definition clause ends, then may not kindly see other clause duly elected or meeting advertisement issued. Then may not kindly read 9. The substantive part of the rule. Form of application. The form of application for appointment shall be such as may be determined by the Central Commission from time to time. And the mode of submission of such form shall be exclusively online. The form of application given. Pro forma of the application shall be published Central Commission website. It has been published, not placed before the court. Here there's specific clause regarding teaching experience. That is not placed, that has been suppressed. Now, fees, etc. Lakshmi will have to see the form, I shall show you the form. See the form. Come to see the form. I'll show the form. We have a specific space. They say, are you working as an assistant teacher in any government school? Yeah, I don't. There's a question is there.
That is the issue. Why government school and not a private school?
Correct. That issue is being raised when? When they knowingly appeared in the examination under the rules and filled up the forms. At that time, they did not say, why are you asking me at this experience? Whether this is a malified application, and come to that later on. This experience counts is also a form. Now, let kindly see now, next substantive part. Then I'm omitting submission 10. This is method of SLST and for selection of candidates and preparation of panel. I'm now assuming the rule is valid as Madam said. Then only this question arises. Under the rules, what is provided is to be seen by law. That they say, according to their interpretation, this mark for the teacher experience should be given at the time of publication of merit list. And another view, and Mr. Dhar has published also, that 10 marks will be given at the time of publication of interview list. Now, interview list has been published or is to be published today. Whatever it may be, it is ready. Now, we do not know whether the party who have examined, etc., they have given the 10 marks
or not.
Now, if they have given, then the question of objection arises. I think if they know it has been given, then they have to argue this. Now, then what the court normally does, if a body, when the two interpretations are possible, they are assuming they are possible, which is not, I just show you also not. Even if possible, the interpretation or the view taken of the rules by the authority, if it is not totally irrational, that has to be accepted by the court.
Yes.
So they have not argued that this reading of the rule and giving the marks, etc., make it that interpretation cannot be made by anybody, no reasonable person. Now, therefore, the approach is wrong.
All right.
Giving their views only is not enough. They have to say the other view is preposterous. No reasonable man can take in that view. That argument not made. That is the basic principle. Now let's see whether the argument has not been made and rightly not made, because rule expressly provides that the marks will be given when.
All right.
Now let's see 11 is a method of this substantive part. Nobody can depart from this. Method of SLC selection of candidate, preparation of panel. Once application submitted, Rule 10, Central Committee shall secure it. I'm omitting that. 2. This 2 is important. Central Commission, after receiving application form, shall prepare a list of candidates for the purpose of database preparation of the preparation of data. My lord, copy is clear. My lord, copy is clear.
Yes.
Clear. My copy. Preparation of database after making preliminary scrutiny of age and qualification of the candidates, which make them eligible to appear in the OMR and base test. First list we published for who can appear in a written test. Is the first list. That is on the basis of age and scrutiny of the applications. Now, let's see when the second is coming into place. Just stages. First is for written test. Now let's come. Then what happens next stage? Then appoint external auditor, the appoint moderator, duly appointed, professor, etc., well, scrutiny, etc. Then not come to Roman 5, V. Central Commission shall publish in its official website preliminary model answer keys after written test and may invite suggestions and the objections from the applicants. So after appearing a written test, this is very peculiar rule. After appearing in the written test, the examinees would know whether their answer is correct or not. Model answer is coming, it has come within 7 days in this case. So when all these applicants are made, they know whether their written test is likely to succeed or not. Their model answers are there. Final model answer has to be prepared, given. Then objections are invited to the model answers. Objections are similar, shall be provided. Central Commission to publish a preliminary model answer keys up to within of written test and may invite suggestion, objection, etc. Then, provided that suggestion, objection must be submitted within 5 days after publication of such model answer keys and should be supported by at least 2 authentic academic publications. The Central Commission shall form a subject-wise expert committee comprising not less than 2 members of the rank, not lower than professor of college, university. Expert committee shall deal with the suggestions, objections, if any, received from any applicant. The decision of the committee shall be accepted by the Central Commission and shall be binding. Expert committee binding. So what is the model answers will be finally settled by expert committee. And that will be published. There is no mention in the writ petition that model answers have been published, have been given, and final model answers have also been published when. And they know what are the correct answers, this petitioner, and they can compare with their answers, and obvious similar they have found that their answers not correct. Their chance of likelihood of getting through the written test is remote.
Is there any cutoff marks
Yes,
that you
yes.
have to get something in the written examination?
I'm coming to cutoff mark is later on coming to. Therefore, my point is, these petitioners have suppressed the fact when the model answer knows, I am instructed within 7 days from written test. I've given also in a list of dates, written test on 14 September or something, for different classes, different subjects. So, long before filing of the application, they knew whether their answers were as per the model answers and what was the chance of success. And it's obvious they realize the chance of success is remote because the answers, they now come with the application. And move the application when I'm pausing here. See the next stage. Next day. Central Commission shall finally upload 7 million. Central Commission finally upload on your website final model answers keyboard. This has been done. Final answer, which is binding on everybody. They can compare with theirs. Then age is very important. Thereafter, what happens? Central Commission shall prepare and publish in its website preliminary list with details of the candidates to be called for interview is subject to verification of credentials and eligibility. Then category-wise, and on what basis? On the basis of preliminary merit score as defined in Rule 1K is a ratio of 1.6 into 1 for final vacancies, and that is 1.6 times here. Therefore, not this final the list for interview, which is due to be published today, I'm told, everybody is saying so. That must be prepared on the basis of preliminary merit score as defined in Rule 1K. Now see Rule 1K. It's Rule 1K. It doesn't mention Rule 1F. or L, 1K, not L. Interview list in respect of SL state level, etc. means in case of vacancies in the post of assistant teacher, a list of candidates prepared by Central Commission to be called on merit for oral interview and lecture demonstration category wise on the basis of preliminary merit score, that is some from written test and the TET for upper primary and academic score in the ratio of 1, etc. What is academic score? Now see, definition of academic score. Schedule. Yes, see. But we're talking, academic score. 36. Page. My page that clear. I'm not able. That's it's one million now for you. Academic score. Academic scores. The schedule 2A. Schedule 2A. Selection 9 and 10 shall be made on the basis of marks obtained in the written examination, educational qualification, prior teaching experience, oral interview, lecture demonstration, determined by Central Commission in the following manner. That's the select sequence. That when the merit list comes, everything will consider how much it scored in them. Now the sequence of events is mentioned here. Now you will see academics. A written examination, 60 marks. First one. Academics has got 2 parts. Educational qualification, 10 marks. Similar based on what? Based on marks, graduation or post-graduation in subject for which applied, whichever is higher, according to the following formula. Similar is also 60%, 10 marks, below 10 marks. Nobody objected to do this. Nobody objected to this. Why you make different? Why 60% will get 10 marks? How is it relevant at the time of teaching? Nobody has said so. Down 6. No rounding allowed. Then B, prior teaching experience, 10 marks. There also it is stated 2 marks for each year of service. So maximum 10 marks can be given, provided there is 5 years of teaching experience. Now teaching experience, appointments are being made for government schools, government-sponsored schools. And they know, everybody knows, government schools, mode of education is different from private schools. They are not same. La Martiniere, St. Xavier's mode of teaching is not same as the government school. So they are asking for teacher of government schools and asking for teaching experience of government school teachers. Now, again, anybody said that the teaching experience in the government sponsored school, etc., is not a matter of weightage in case of appointment in government schools. It is not a case of appointment in private schools that we are asking for your teaching experience in government schools. Then that could have been not relevant. Now, therefore, but I am first on sequence. Sequence part, prior teaching experience, 10 marks to be given after secondary. Then that is to be given before oral interview. So that is to be given before the final list of oral interview is published.
That means at the time of declaration of this
Yes.
2K, that is the interview list.
Yes.
The 10 marks is to be added.
Added. Then on the basis of that, the final list of persons who are to be called for interview will be published.
Yes.
Which is supposed to be due to be published today.
All right.
Now, if the examiner or the authority has proceeded on the basis, just 10 marks is to be given at this stage to before publication, for preparation of final list of interview. Can that said to be irrational? That's the question. Now, this is rule clearly provides, first thing I submit, my lord, is most unfortunate, if I have humble submission, that definition has been shown, schedule has been shown, but substantive part of the rule 11 has not been placed, your lordship. And that clearly says when this marks are to be given for teaching. Namely, I go back to the substantive part of the rules. Clearly showing me, it should be done. Let me not see me not. Hey, this is me not. Have you late I was reading?
Yes.
Read once more to say this is a
Yes.
If I can permit me to read just once more, that I allow this repetition. Is for the Central Commission shall prepare and publish in its website a preliminary list with details of candidates to be called for interview, subject to the verification of credentials and eligibility. Category-wise, the list should be category-wise, and on the basis of what? On the basis of preliminary merit score as defined in 21K. Defined in 21K, not 21L. So, my lord, in my hamster is very clear. Hands of the examiner are tired by the rules. You have to, as per the reading, they have to take into account the teaching experience marks, if available, to any students at the time of preparation of interview list. There's a second list to be published. First, written test list, now second interview list. Second, a further list to be published. Thereafter, he may not want to know. He will not kindly come to the list is finally published on website, then kindly come to me not 9. That's not the end of, that's not final, not end of the matter. To prepare the preliminary list as referred to above, marks obtained by the candidates were secured test position on the basis of ratio, etc. shall be the cut-off marks. She was cutting marks. The lowest mark is obtained, that will cut-off mark for a particular category. If, however, said cut-off mark is obtained by more than one candidate, all such candidates who have obtained a set cut-off mark shall be called for interview. This is the further scrutiny. Then, my lord, unless a candidate secures the cut-off mark in the particular category, he shall not be considered for that particular category in any subsequent stage of selection for that category, irrespective of his merit score obtained after interview in any other category. So, merit score to obtain even after interview will not be considered. That is similar if he not has reached the cut-off mark. And cut-off mark will be fixed on the very lowest after taking into consideration result of written test 60 marks and result of that academic code 10 marks for 10 marks, 10 marks for teaching and another 10 marks for I'm scheduled to that one. 10 marks. 10 marks for 10 marks educational qualification. Educational qualification mark has to be taken 10 marks and primary teaching, prior teaching. Both are to be, therefore, my lord, sum total of written test 60 marks maximum, and that is whatever the case. Then 10 marks maximum for academic success, first class, second class, whatever it may be. And third is teaching experience. All these categories are combined and known as academic. And Rule 11.8 clearly enjoins that all these have to be taken into account. Then final list for interviews to be prepared. And that final list will thereafter will be vetted. Will be vetted and the cut-off mark is to determine. Now if I read on it. 10. preliminary list of shortlisted candidates prepared Central Commission shall be forwarded to this. So therefore, after the scrutiny, the shortlisted list of person to interview published. That's the third list which is being published. Third shortlist. Thereafter, regional commissioner shall verify the credential eligibility of shortlisted candidates, appearing interview, etc. I cannot do my portion been checked and found incorrect, any incorrectness, etc. will be corrected. That provision is 11. Then commission during documentation in case of doubt, disability, etc. may refer to the competent medical authority, etc. That is to be checked. That is a provision for checking that. Then regional commission, verification document, etc. Veracity from the then upon verification, respective regional commission shall submit report. Now see 14 million. Upon verification, respective regional commission shall submit report to the central commission as to the outcome of the verification process. Then 11. Now 15. Thereafter, upon verification, etc. Thereafter, the Central Commission has prepared a consolidated interview list, which shall be published and to be forwarded to the interview board as specified in Schedule 3. Third time, a consolidated interview list and to be submitted to the board for after next clause. After interview board shall forward a detailed report to the after interview. Then interview will be taken of those persons who are in the list. And after interview board shall forward a detailed report to a central commission, which from the interview list and on the basis of report of interview board, prepare and publish a merit list category-wise on the basis of merit as per Schedule 2. Merit list shall contain the names of eligible candidates who have appeared for interview. Now let's see merit list Schedule 2. Merit list preparation. Schedule 2. Then is the next lecture demonstration 10 marks will be taken. Then those who have been interviewed, my lord, they will have to give a lecture demonstration. They have to actual teach the students, attend the classroom and teach. And on the basis of their performance in the actual performance on the stage of teaching, they'll 10 marks allotted and they will get a board. Lecture, as you call lecture demonstration, lecture to the students. And all these marks will be an appearance before the interview board is compulsory. Selection and post lecture on that basis, the merit list will be published thereafter. Now, this prior teaching experience marks is different. For the lower classes, is different. See. Now, Miller. Now, there in case of classes which are below, not 9 and 10, upper primary level, the primary teaching experience is 5 marks only.
Oh, here nobody is from the upper primary level, so we will not look at it right
Primary
now.
level,
Upper primary, no candidate is here.
upper primary something.
It is
and
only
for,
9, 10 and 11, 12.
For the upper primary level, and no concern with that. What I'm showing you, Milot, is a expert committee applied their mind and allotted different marks for different categories. It's not problem. Therefore, in my submission, Milot, on plain reading of the rules, there cannot be any doubt that if the interview list has been prepared by taking into account teaching experience, that will be totally unreasonable and nobody can take it. Now we have to assume the rule is valid, and all these parties have applied on the basis the rule is valid. and rule is binding on them. And my lord, in the question form, application form, there's a clause. Are you working as assistant teacher in any aided sponsored schools under government? Question is there. Then again, next experience count each completed year. Each completed year means 2 years. They know that. If the fresh candidates may have experience in government school teaching, may have.
How can that be? They must be appointed in some
No,
manner.
previously appointed. Government school is not born in 2016.
Previously appointed, the age will be bar. How can they come? They cannot come.
No. Government schools are in existence from when?
If somebody is in existence or has taught, then the candidate will be quite aged.
Before 2016, there were government schools or not?
Those the age criteria will not match.
Age. That is an assumption. Therefore, my lord, those persons
Cannot be given any chance.
No, those persons who were in government school teaching as teacher, and there could be teachers of government school prior to 2000?
16.
Huh? No,
2016
2000?
selection process got cancelled. 2016.
That's right.
So 10 years. Where from will they get this age benefit? They will not get. Only because those candidates suffered some problem. This is the reason this age relaxation is given.
Right.
Freshers are not getting.
Now, Lordship is going to rationality of the rules.
Yes.
Now, but the rationality rule, Lordship on the decide, I can make further argument. I made up to this, that at what stage a mark to be given, right
Yes.
or wrong, under the rules.
That also
That
you
is my argument. First argument. And nobody has said this reading. And the funny thing is this. Today is the date of publication. And today application is being moved.
There are pending applications also. There are pending applications.
Pending. But today is become urgent because rule is being published today. And what is the effect of it?
It was filed very.
What is the effect?
It was filed.
I mentioned later anyway.
No, it was mentioned the other bench was possibly hearing the matter. Now with the change of determination, it has come to this bench.
But whatever reason, act of court can cause no prejudice to anybody.
Right.
Whatever reason, matter is being taken up today. And court will decide whether any order is called for on the date matter is being heard.
Yes.
Or whoever faults may be.
Yes.
Now, when the final list to be published today, and court not knowing what method they've applied, I'd ask them in the dark.
No, they have taken specific instruction from the commission's office, and they have been told that the marks will be added. Prior teaching experience marks will be added
What is
at
that?
the time of the
Very-
publication of the
where-
written
where-
examination.
Where?
No,
For that paragraph.
no, my lord, no.
For that paragraph.
If the stand of the commission is that 10 marks is not added now, it
Mr.
will be
Bandyopadhyay
added.
is there. My lord, I will address it. I will address this point.
Only one thing,
Am I audible? My lord, am I audible?
I can hear you, Mr. Bandyopadhyay.
only one point.
Can I place my case, my lord? There are hours and hours they are
Mr.
arguing. Give me chance, my lord, 5 or 10 minutes.
I will give you days and days, don't worry.
I do not want, my lord. This is not a
Yes,
case that
please.
hours and hours to be
Very
argued.
grateful to my learned senior Mr. Mitra, my lord, for placing rule 11.8. Kindly come to rule 11.8. There is one in the second line. There is one important.
Why haven't you placed that?
My lord, case is not only between the petitioner and the private
Dealt with
respondents.
that. Relevant. It's the most relevant.
Case is not between the petitioner and the private respondents. What is the course of?
My lord, rule 11.8.
Yes.
The object to verification of candidates and eligibility.
Yes.
This means, my lord, at the time of kindly consider this very important.
My lord, your
Time
lordship
of
can
filling up
give me
the
chance.
online application form, no document was uploaded with the application form, only the information. Now, till date, my lord, I have taken instruction, my clients are also present, that no notice has been given for calling the candidates for verification. Only after verification an interview list can be published.
So today, as submitted by my learned senior Mr. Dhar, that today is date fixed for publication of interview list. It
No, no.
cannot be.
No, no.
It cannot be because
Yes,
without
yes, he is correct. He is correct.
We-
He is correct.
Well,
Mr.
without-
Dasgupta is correct.
না আমরা দেখি বলুন আমি তো
স্যার আপনি কি শেষ করবেন আজকে না অন্যদিন
Sir,
করবেন?
at seconds. Sir, my lord, without verification, there cannot be any interview list.
স্যার আপনি কি আজকে শেষ করবেন না অন্যদিন করবেন? তাহলে আমি
Paragraph
একটু অন্য
6,
কাজ করে
my
আসি।
lord, I have pleaded in paragraph 6 what I have said.
প্যারাগ্রাফ 6টা দেখি দাও এবার ঠিক বলে দাও your petitioner state
May I read?
the paragraph 6 can you read me lord the petitioner visited the office of concerned respondent authority to gather information with regard to schedule, time, and procedure conducted for interview round. When the petitioners were informed that 10 marks out of 100 awarded for prior teaching would be given to candidates participating in the recruitment process before the interview round. So, who has said so? No, this is let us come to pleading. They don't
One thing.
no name anybody.
No, your submission is that the interview list that will be published will contain the
No,
10 marks.
And paragraph 6 is to be ignored because the
All right,
pleading is has to be said.
Your submission is that the interview list will contain the 10 marks. This is your submission.
Interview list should contain.
Should contain. Just now you read out 8. It says subject to verification of credentials. The credentials have not been verified till date. How can the interview list be published?
That is new point argued.
No, no, it is you who placed this.
No, I have placed.
You have
but verification
placed.
is not done. Who said so?
The parties.
Who is not done?
Sir, your client has appeared in the written examination. Did you take instruction whether their credentials have been verified?
Please come.
They have not.
Please come back to the rules. Verification how to be done is also mentioned there.
But this kindly give me 5 minutes. This all problems will be resolved. Give me 5 minutes. Give me 5. All confusing. Lord, this kindly give me 5 minutes, 5 or 10 minutes. Then kindly hear them. Give me 10 minutes.
Application.
Yes.
That will made as a type of filing a written test.
It has not been done.
Then written test list was published and without verification.
This is the commission's way of functioning. What can be done?
No. We are not. Whatever Mr. Mitra is saying, that is no.
Kindly hear Mr. Bandyopadhyay.
Mr. Mitra's submission to this extent is not correct.
Certainly.
Let us hear.
10 minutes. This is answering only this. Verification done at the stage of test.
2 hours, they will
It
take
is
time.
formally done.
Let the commission say whether they are verified or not. Let us hear.
I shall.
Yes, Mr. Bandyopadhyay.
My lord, kindly similar. I have 2 or 3 first, my lord, the objections.
Yes, please.
Lord, the read petition is not entertainable by this court at this stage.
Right.
Because the read petitioners all appeared in the examinations.
Right.
And my lord, to this extent, I am citing a judgment, my lord, 2024 SCC online 1511. Paragraph 6. My lord, may I read, my lord?
Yes.
The contentions of the appellant are not acceptable. This has in fact been dealt with the High Court. The conditions stipulated in the corrigendum is no more amount to a change of the rules as has been argued before the. Moreover, the appellant was fully aware of the rules and those conditions under which he had participated. Once he has participated under a rule, he cannot challenge the rules to be unfair if the promotions have not been made as he would have wanted. This important aspect is the promotion have taken place as per. Now, once he has appeared, then my lord, he cannot challenge the rules. Second point, my lord. Similar, just I did tell you, very short. The fact is, in the Orunima Pal's case, entire rule was challenged. Now, my lord, entire rule that was dismissed, here dismissed, even in the Supreme Court, it was dismissed, excepting certain portion. Then, my lord, successful candidates, I mean, untainted teachers also filed so many petitions in Supreme Court. Either challenging the Orunima Pal's judgment and other judgment, also Article 32. Supreme Court is examining the entire rule. And that is fixed on 24th November.
This 2025 rule?
Yes,
Nobody had
yes.
submitted this.
No, they have not said.
I said, my lord, yesterday I did say, I
They
placed
said.
that only my.
Now, my lord, what I would be.
SCP dismissed, but whether this rule is under
Yes, yes. Yes, my lord, I will show. If your lordship give me time, I will.
Some saying no, some saying yes. What does the court?
My lord, in that case, give me some time. I will show you the petitions also and whether there are submissions. My lord, may I just take it from me, my lord? Just take it from me. Please, Mr. Dasgupta, all you have taken time. My lord, the Supreme Court has said, kindly take it from me, on 24th November or whenever they met, entire thing would be scrutinized. Second, that is, I leave it to your lordships whether your lordships will examine it or not. I am telling your lordships the fact. Therefore, this is, my lord, everything is under the scrutiny of the Supreme Court. Just I tell your lordships this. My lord, I will be requesting to your lordships that give a directions or to move them under Article 32 before the Supreme Court, because so many multiplicity of the litigations are not expected. Whole rule can be seen there. They can go under Article 32 also when this is being looked into. This is the one of the part of the matter objection, and also it will not be rather proper at this stage by the High Court to go into this. Third is a delay. Well, delay maybe 1 year delay, maybe 6 days delay is also factor. If at all, without waiving my submission that they cannot challenge the rule, they could have come earlier. They did not come earlier. Your lordship was still observing just a change of determinant. That is the last week. 3 or 4 months, they have not challenged it. Today, we are going to publish the only candidates who appeared in the written examination with their marks. Nothing more than that. Thereafter, my lord, the verification will be done within 7 days. 7 days or 10 days, just take it, my lord, at that time. This is one group. My lord, only 11, 12 will be published today. 9 and 10 will be published within 2 or 3 days. But this argument I have also made in the Supreme Court also. Supreme Court has given us time, that's all right, you continue with this. Verification, etc. But then after verification, what stage is coming? Before interview? Yes, before interview. First, I have to verify that whether any teacher who has, any candidate who has applied and passed in the examination, whether he is the eligible or not. But let's take it, Milord. There are some cases, we have given it, said it in the Supreme Court. Supreme Court has also given us the liberty. Some cases, maybe some tainted candidates have been missed. Let's just assume for argument's sake. But at the verification stage, we can also say, we can also detect them, cancel. Similarly, the untainted teacher who are claiming untainted teachers altogether, whether they are all untainted or not, that would be verified at the verification stage. After the verification stage is over, now Milord, kindly come to the rules. The lordships have gone to the kindly come to Milord page.
স্যার আপনি আইটেম নাম্বার 2 না 3 তে বলছেন?
ভাই আমাকে তো যেটা বলছো যেটা চলছে লিস্টে দেখাচ্ছে সেটাই তো করছি। Anyway, subject is same. Milord, inter 2K, kindly see 2K. Interview list. Interview list in respect of the SLST state level selection means in case of vacancies in the post of assistant teacher, a list of candidates prepared by the Central Commission to be called on merit for oral interview and lecture demonstration categorized on the basis of the preliminary merit score from written test and or TT for HON'BLE so and so, and academic score in the ratio of 16.1 final vacancies. And this academic score your lordships will find here the policy rule. Schedule 2. Well, along with the prior teaching experience. Therefore, interview this preliminary merit score and also academic score. Then you'll also kindly see merit list. 2L. Merit list in respect of the SLC state level selection test means in case of post, a list of candidates prepared category wise on the basis of merit which shall mean and in addition to what has been stated in Rule 2K marks obtained in oral interview, lecture divination and prior teaching experience shall include all the eligible candidates. That is a wide definition. And at the time of preparing of the merit list, we will take into consideration all things, everything. That doesn't mean that the prior teaching experience is not included within the 2K, because it is within the academic. But that has been more clarified what Mr. Mitra was submitting under Rule 11K. Today before a lordship is 2K, today before a lordship is 2L, and today before a lordship is 11. That Mr. Mitra was submitting, that 11. Roman 8. The Central Commission shall prepare and publish its website a preliminary list with details of the candidates to be called for interview, subject to verification of credentials and eligibility, categorized on the basis of the preliminary merit score as defined in Rule 2(1)K in the ratio of 1.61. Malad, your lordship notes the rule of interpretation. There is a harmonious construction. And with the court object is not to destroy the rule. Court object is to preserve the iron. Now, kindly similar, your lordship takes this chip very clear. First is written examination result, verification, then the academic score, then it comes below the interview. Interview what? That's the two stages are there, oral interview and the demonstration is there. This is the case. But there I cite one judgment to your lordship. Only take this. Give it. The 2000, Justice Malami says, Dipankar, the 2024 SCC online 3776. SCC online 3776.
SC 24 SCC online 377.
Kindly come to paragraph 6. The contentions of the appellants are not acceptable. This has in fact been dealt with by the High Court. The conditions stipulated in the corrigendum is no manner. Sorry, I am very sorry. Kindly excuse me, Miller. Kindly excuse me. I am very sorry. I am sorry. I have given a wrong citation and I was in 2024 SCC online 3776. Kindly come to paragraph 24. I'm very sorry. In state of Rajasthan versus Sannam Lodha, this court was considering whether absent a challenge to the law or rule, this same could be read down answering in the negative. Honorable R.B. Ravindra and J. So it is true that any provision of an enactment can be read down so as to erase the obnoxious or unconstitutional element in it or to bring it in conformity with the object of such enactment. Similarly, a rule forming part of an executive instruction can also be read down to save it from invalidity or to bring it in conformity with the avowed policy of the government. When courts find a rule to be defective or violative of the constitutional or statutory provision, they tend to save the rule wherever possible and practical by reading it down by a benevolent interpretation, rather than they declare it as unconstitutional or invalid. But such an occasion did not arise, and in this case, there is no challenge or to the validity of the Rule 5 so and so, and therefore of the view that in the absence of any challenge to the Rule so and so. Now let's come to the prayer of the petitions. Kindly see. Page 21. এটা শিশির দাস a declaration can you say declaration declaring that the respondent authority and its agents to abide by rule 21K and rule 21L of the West Bengal School Service Commission appointed to so and so and the rules to thereby awarding prior teaching experience after the interview round in connection to the recruitment process 2025. His interpretation is this should be done after the interview. Our interpretation of the rule is this, that it has to be done before interview. Therefore, he has not challenged the entire rule. He is asking the marks should be added after interview. And according to our rules, our interpretation is before that. Now, next second, a writ of in the nature of mandamus to issue commanding the response their agent servants subordinate employees assigns not to award marks for prior teaching experience in calling a candidate for interview in connection to the recruitment process. Therefore, today I don't know whether what is your lordship's mind is, whether your lordship is finally hearing the matter, or we have to file an affidavit, no doubt about it. And at this juncture, the question of passing of interim order does not arise at all. That will absolutely allow the writ petition itself. Kindly remember one thing, we are running against the time. That is the whole difficulty we are seeing. Yes, that day also I was telling to a lordship. 31st December, I have to declare the result in terms of the Supreme Court's order. With great respect, I tell you, with great respect to your lords, any type of intervention in this matter will nullify the order of the Supreme Court by 31st December 2025 has to be done. And prima facie, I have a case I have shown to your lordship. This is the case. And I will request and beseech to your lordships. I will rather beseech to your lordships in this matter. So many applications, so many writ petitions have been filed. Why they are avoiding Supreme Court now? That's much I am telling you. With a guarantee I am telling, everyone is avoiding Supreme Court. Give them leave to file before the Supreme Court under Article 32.
Please
Any
show
sorts of
document. Please show me some document that this issue is pending before the Supreme Court and 24th is the date fixed for hearing of this.
In that case, kindly take it on 12th. I will show you.
No, there are so many. Please show me.
The copy of the SLP is required to be produced before your lordship.
He's showing something.
Let him show something.
I will show that the Orunima Pal's judgment, where Orunima Pal's judgment, the entire rule has been upheld by the division bench, was challenged by them.
This was placed yesterday.
I placed yesterday.
We placed it yesterday.
The exact thing should come to rest after. Because this 10 marks granting or not granting the division bench held, and it is not arbitrary.
My points have not been dealt with in Orunima.
The question was whether that particular rule was arbitrary or not.
Was the rule under challenge?
Yes.
One order from my CAN application.
You have a copy of the no, this order. Have a copy? Please check up. Page 24, this line was placed yesterday.
And then she's 34.
1 minute, please. Page 24. Sixth sentence, the recruitment rules has not been challenged by any of the appellants.
That is not
Incorrect.
probably not correct.
See, this is the court's order.
Yesterday it was shown to your lordship. Yesterday it was shown to your
This
lordship.
line was also
With
shown.
respect,
And in this single page,
they with you, Mr. Bandyopadhyay showed it to your lordship.
Yes.
I wanted to
Right.
show the prayer of Orunima
Or
Pal.
please see paragraph 28 of this division bench. Please see 28.
Was under challenge.
It was.
But thereafter not proceeded with.
Yes.
No, before the division bench,
There is a difference.
There is a difference
Yes.
between not challenging at all
Right.
versus
And
I
abandoning.
challenge, thereafter I, just a second,
see the prayer.
challenge and thereafter I find I don't want to continue because of XYZ reasons which may not be suitable for me, so I give up.
Yes.
This was a case of given up, and that was recorded by the division bench.
My lord, all the councils.
Respect of one petition, in
My lord,
respect
kindly
of one
see.
candidate who's not a party over here,
Correct.
right?
Correct.
So the court, when the litigant gives up the issue,
Yes.
the court doesn't have any scope and an occasion to
Look into that.
My lord, that is your lordship is absolutely correct.
Correct. No
My
doubt.
lord, your lordship is absolutely correct.
My lord, there
But
are-
what I am, my lord, that is your lordship is absolutely correct. My lord, whatever it may be, ultimately it will be decided by the Supreme Court. There, my lord, Article 32 petition is
After Mr.
Article
Bhatt.
32 petition is
I
maintainable.
don't take soft copies.
Article 32 petition is also maintainable. They have moved so many Article 32 petitions.
What is pending in 20?
Because time is a very important factor here. That is the reason I am saying. Otherwise, I would not have argued this point, your lordship. Your lordship is having all jurisdiction powers, everything to examine whoever the litigant is approaching before your lordship. But here is a case, your lordship knows this, the entire thing, that if your lordship, then of course, if your lordship entertain the petition, we will file an affidavit, thereafter matter would be heard. But
No,
any
this is a
type of
point
interim
of law. This is only interpretation. There is no affidavit to be filed because factually nobody is denying or
But
disputing.
only one thing, kindly record that I wanted to file an affidavit, but affidavit is not required. Your lordship makes this interpretation.
According to me, everything is.
I have to put on record all these documents. What your lordship is saying, where is these documents, where are that other documents that I have to place it before your lordship.
The Bandakota is correct. Your lordship kindly come to page 41
of
my can 1 of Shishir Das matter. Item number 3.
Can one টা দিন তো দেখি।
Can one দিন না?
Page?
Can one.
Page 41.
Milord, with your lordship's leave, may I go, Milord?
দেখি শিশির দাস
কেউ যাবেন না?
No, Milord, with your lordship's leave, may I go, Milord?
রিট পিটিশনের নামটা দেখুন না।
চলে যাচ্ছে কেন?
শ্রী দাস ক্যান ওয়ান এটা কোনটাতে?
This is can 1, your lordship.
স্যার একটু থাকুন।
পেছনটা দেখুন শিশির দাস।
Milord, with your lordship's leave, may I go, Milord? With your lordship's leave. Can I go? Can I go, Milord? With your lordship's leave, can I go, Milord?
Yes, Mr. Bandyopadhyay, certainly.
Milord, deeply obliged.
All right.
Two is completely different. I tell you.
Oh, 1 minute. Mr. Sanyal was showing some. 41.
Sleep over page 41, 42. Have a look at 43 only.
Yes, 43.
এয়ারড্রপ করতো?
Operating portion, next page, page 44. The last paragraph. The matter need not be listed on 31st October or 31st October. Even if specific dates have been given in any of these batch of matters, as they would necessarily have to be heard together. We are informed that the results of the selection test held on 7th September 2025 and 14th September 2025 would tentatively be declared in the first week of November 2025. List on 26th November 2024.
26 is mentioned. 24th.
All these have been applied.
Oh, my lord.
Oh, 1 minute. Page 41 that you placed is a matter of Vivek Paria. Where is
Place that order yesterday also.
Vivek Paria, was it placed? I cannot.
We have given a copy of it.
So because every matter, a bunch of matters were heard by the justice. Bhattacharya and the jurisdiction bench presided over justice. All points are included.
Because Orunima Pal has been highlighted. I cannot recollect that now.
Yesterday Orunima Pal was highlighted.
Yes.
Division bench and several different. Vivek Paria, my lord, the issue was whether there was a criteria 45% has to be
No.
45% or 50%.
Incorrect.
Challenging that division bench negate, no, the qualification fixed by the.
Mr. Mitra appeared for Vivek Paria before the High Court.
Listen, thing is whether this 10 marks
No,
prior teaching experience, this issue was hard.
Let them show some My lord, let the SLP's copy of the produced, whether this 10 mark issue is in challenge in those SLP.
Even yesterday, you lost SLP copy.
Whether this 10 marks can be point of law grounds, can be sitting ground.
And
Showing one
an issue has been raised as to why do not you take it up before the Supreme Court, the whole thing.
Court fixed. But in fact, my lord, this should go before the Supreme Court.
Oh, I didn't see you. I missed.
Just
Well, he just now came, my lord.
My lord, and Article 35 petition was used directly by one of the candidates. The Supreme Court deprecated, no, you go before the High Court first. And another matter, my lord, the High Court refused to entertain. Supreme Court said, no, you first decide. That is why, my lord, your lordship will find all are special leave petition, not a single Article 32. All are from special leave petition. My lord, let the copy of the SLB, if their candidates are appealing, their
In
clients,
Vivek,
let the copy of the SLB be produced before your
Vivek,
lordship.
You lost the SLP copy.
Yes, that it was
yesterday,
given.
is it there in the file? All right, I'll check it up.
Here also kindly remember,
Wait.
point of law number 12, ground number 12. Now, other point, each point is pending before the Supreme Court. My legislature was asking that whether we are out of expiry of the panel appointed candidates or not. If so, they will be tainted. Now, well, please order the losses can.
1 minute, 1 minute. Vivek, SLP, which ground and
Ground number 12.
ground 12.
Ground number 12.
All right,
I put a tick mark for the losses.
all right, all right.
Yesterday has been given for the SL of Orunima. Orunima was hard with Vivek. I'll show to your losses there. It's a bunch of things.
Was Vivek's SLP given or not?
Your losses can even look at all the matters and hard analysis.
No, but then is it in one matter
But
only?
what happened? There are a bunch of these petitions, hard and disposed of by the division bench. One SLP was taken together, another SLP was moved.
No, no, Orunima Pa's SLB was only restricted to certain points and Vivek was restricted to certain points. Your lordship,
The fact remains, my lord, the entire thing is pending before the Honorable Supreme Court.
The entire thing, there are issues.
My lord, this issue, the issue which is being heard.
Show me something.
Keep it on Monday and produce the document. Keep it on Monday.
The other points,
Monday.
we are not.
Monday.
But why will the court look? The commission is there to look into it.
No, I'm showing to your lordship that everything is before the Supreme Court. Right.
Yes, and the commission is the authority to see who are in the panel, outside the panel, all these things.
Point was asked in this petition. Justice Bhattacharya in the single bench said we cannot do it because Supreme Court is in.
Yes, whatever
Then
the
Malad went on appeal.
Division.
Appeal court Justice Division bench presided over Justice Papabhutto Chakraborty held the same view.
my lord, that has been challenged. That has been challenged by the list was challenged by tainted candidates. We do not fall under those candidates. Completely different, my lord. Your lordship can consider the writ petition. It will be clear to your lordship.
yes.
Paragraph 10 and the operating portion of the law.
It's considering about tainted candidates. Kindly see what was the issue, my lord. Kindly consider
Question
that.
of law. It's a question of law. Stated 10% of.
Yes, question of law. Then why it is pending before the Supreme Court? I also say it's a question of law.
And the operating portion your lordship of the order.
Well, kindly read the order, the issues raised in that writ petition. Completely different.
Candidates were allowed to continue their service, but they were appointed after expiry of the panel, and their names do not feature in the list dated 30th August. This is exactly the submission of Mr. Dasgupta.
No, their submission is that the commission is to see who are tainted and not tainted.
He is arguing that these sort of candidates are coming within the zone of tainted. Yes, that submission. So this is the same argument.
No, that is completely separate and nothing has to nothing to do with the 10 marks.
Now before the Supreme Court.
That is the eligibility factor which the commission will consider. Whether they are eligible or not eligible, that is not the issue.
Qualifications, not these ones.
No, the Supreme Court has said
That's one of the other
will be able.
cannot be allowed at all.
Yeah, that is also an eligibility.
That's one of the points. The 2
The
points are
points.
involved.
So that the commission will see. That is not the issue.
They are arguing
That
whatever argued before your law.
these are not very relevant. What is important is whether this 10 mark issue is pending before the Supreme Court. Please show. Yesterday. All right, I'll check it up.
My lord, may I?
And the issues also. In a very short and a concise manner. Otherwise, see the documents over here. Yesterday's.
My lord, you have said, see this is judgment of division bench, where this point was teaching 10 marks were raised or not. Please see paragraph 6.
Which one? Which judgment?
So, this is Showman judgment.
Arunima Paul?
Yes, see paragraph 6.
This
Can
is
you come?
16th July's judgment.
Paragraph 6, I have compressed it. Then paragraph 6, middle. Mr. Bhattacharya submitted because in the middle, it is submitted that prior teaching experience for 10 years was not an eligibility criteria in earlier notification. Moreover, the percentage of marks has been arbitrarily increased from 45 to 30. This is the second point, and made malafide make them disqualified. Other is in terms of now, similar when this matter comes up before the High Court, I mean to the learned bench, what they're considering, what they're saying. No, but I think court is being misled. দেখো বার করে দাও এখানে কোর্ট হোল্ড করছে এখানে প্যারাগ্রাফ 34 ছিল paragraph 34 can you see now?
Paragraph 34 has been placed yesterday.
Yes.
Today also it has been placed, and one line is also there that the recruitment rule has not been challenged by any of the appellants.
But it's not challenged.
It is written over there.
দেখো
The 6th line from the top, page number 24.
My lordship may look at from this point of view. It is possible.
Yes.
There are
Awarding of marks. Awarding of 10 marks in is a weightage.
No, page 24. Page 24 of the judgment.
Page 24, yes, 24.
6th line from the top.
Yeah, lordship is absolutely correct. I've
24,
See,
yes.
what is passing through the court's mind?
Can I just conclude? I began. There are
The
two
prior
just-
teaching experience is
not
an
this-
important factor. If prior teaching is an important factor, the experienced teacher may impart education effectively and efficiently.
Next line.
Recruitment rule 225 has not been challenged by any of the applicants. I'm not challenged, but argument was made.
Suppose it is not under challenge, somebody comes up with an
Let me not challenge, just see.
I have
See me now.
yeah,
Has not been
I have an
challenged.
answer to that, and I don't want to take an extreme view. My lord, when a rule particular acceptable, please. Just not, let us not go for
34 has been placed,
Just
Mr.
30,
Chatterjee.
30, 30.
I don't want
That
to,
has also, Mr. Bandhavada yesterday has
I
placed
don't want to
everything.
say, I do not want, please, I do not want to say in that way. Kindly see two things. I do think there is an every possibility, because I'm not going to say I'm 100% confident, but my hunch is there is a possibility that the entire virus of the rule may not be challenged before the Honorable Supreme Court. This is true. At the same time, this is also true that this is a unique situation, unlike other SLPs and civil appeal, where because of a gigantic nature of impact governing the matter, the Honorable Supreme Court is, without using the word monitor, is effectively, I'm using effectively trying to see that my order is actually complied with. So therefore, I do not say that if anyone questions the virus, lordship doesn't have power to enter it. I don't think. I think one can independently question virus, which is a purely point of law, possible, unless it is purely covered. But there is also a thing called a propriety. Now, when the Honorable Supreme Court, in a very unique manner, in this case, is trying to ensure it is complied with, what does it mean? It means we have delivered a judgment, that's the Honorable Supreme Court. Thereafter, X, Y, Z things were our directions. Are those directions being complied with? Now, at that juncture, I do not say that it's legally, I would be able to say that lordship doesn't have a power. Lordship has power. But even if lordship has power, Lordship may afford to say, I don't want to enter at this stage because of propriety. It's not because lack of power. This is number one. Number two, if Lordship wants to see this, because something has to be before your Lordship shockingly wrong. There is a clear-cut judgment by the Honorable Supreme Court in 2024 involving this prior experience. It was by, now kindly have a look at there. This is, it's not page, no, it is not page. This is, kindly see, 2024 SCC online 3776.
Which was
That is-
placed, it has been given by Mr. Gondapur.
I know
Para
that,
45.
but the other para.
Para 45.
I have the, kindly see,
Because-
exact, this was.
One part has cited this judgment, other part.
Let us
Yesterday this was
let us
placed.
have that.
Today he
Yes,
cited.
yes, I know that.
Para
For
45.
today. Oh,
Ki-
then it must be here. Yes, Allahabad University is here.
Yes, kindly
Here, Didi.
see
Yes.
paragraph E at page 3.
Yes.
Paragraph 2E. Kindly see the procedure. Well, there are synonymous words are always there. This is a judgment where the weightage, that's the prior experience, was used for the purpose of shortlisting even. That is pre, which is the case here. E, the procedure for shortlisting candidates for interview is given in the note to regulation 4.1, which provides for shortlisting on the basis of an academic score prepared in, kindly mark the academic score, identical case of ours, with table 3A for universities. Well, just pause. What is table 3? That is paragraph 40. Kindly come page 26, paragraph, page 26.
Yes.
Serial number 7. Teaching, postdoctoral experience, 10, 2 marks. Similar method. Now kindly come back to the same paragraph, 2F. So this table 3A, there also teaching experience was there, and 3B. Hence, for shortlisting candidates for the purposes of interview, Allahabad University would score candidates as per the criteria laid down in table 3A and the affiliated college, such and such. As per clause 7 of table 3A and 3B, 2 marks are to be granted to a candidate for every year of his or her teaching experience or postdoctoral experience. Since the contents of both the tables are similar, we propose to reproduce, they are reproduced. Then G, despite respondent number 1 fulfilling the eligibility criteria, she was not shortlisted for the interview as her score did not reach the cutoff marks. This happened because she was not awarded the marks under that 3A. Kindly straight away come paragraph 48. Because the division bench took a different view, single bench took a different view. The division bench view was set aside. Paragraph 48. We are also of the view that the criteria for shortlisting of candidates as engrafted in table 3 and 3B were in furtherance of the entire scheme of frame by the UGC for appointment on the post of assistant professor in university as well as in college. Clause 7 of table 3A and 3B, having direct relation with regulation 10, did not call for any observation from the division bench of the High Court of the nature noticed above. An aspirant satisfying the conditions in regulation 10 would be entitled to marks either for teaching experience or postdoctoral experience for which a cap of 10 marks is imposed. Regulation 10 on its very terms makes it clear that rendering a past service, well, this is important, law point. Rendering a past service is not a sine qua non for direct recruitment. If indeed a candidate has served in the past and answers all the conditions that regulation 10 envisages, read with clause 7 of table 3 and 3B, as the case may be, he or she would be entitled to marks for teaching experience. In such circumstances, we hold that the division bench completely erred in appreciating the contention issues in the proper perspective vis-a-vis this. Now, similar thing also 2025 Justice Gawai judgment in our professions. My lord, now if a lawyer wants to sit in the judicial examinations, a freshers. I have LLB, so therefore I am entitled.
The district judge is
Now experience of three. Kindly have a look at this judgment of Justice Gawai. This is Justice.
Justice.
Copy touch. I'm Yes. Kindly take 2025 SCC online SC 1184. If I can just say my premise, I say that there is no reservation for freshers. So therefore, it's a competition. In a competition, selector has a right to choose if the pool is available, whoever I think to be the best. Putting experience as a criteria as something which gives a leverage is recognized by the Honorable Supreme Court in variety of matters. Now, this 25, kindly take my lord, paragraph 89, Roman 7. At page 32. Even the direction was that amend all the rules of all the high courts. Romans 7, last para. All the high courts and the state governments in the country shall amend the relevant service rules to the effect that candidate desires of appearing in the examinations for the post of civil judge, it's not district judge, civil judge junior division, must have practiced for a minimum period of 3 years to be eligible for the said examinations. Kindly, my lord, contrast this way. A person desiring to sit in the examination, in this case, is not even be able to appear at all, unlike this case. A freshers who doesn't have a reservations, he would be able to participate. But he will not be getting
a job.
Yes, no, he will not be getting the experience marks.
That means he will not
But
get the job
no,
also.
if he's a brilliant, kindly look at this way. If he's a brilliant, in a sense, if his academic marks are much higher, then he will get. Kindly look at my lord from a, I would say, from a point of view, because both sides may have a story. Both may be reasonable. Now it is lordship would see which is more reasonable. One side is saying that our scope is being choked. That's the freshers. They are going to say this is choked. The other side is that there is a judicial recognition of experience and marks, and that is Justice Datta's judgment. So therefore, it is very well possible for a selector also to say that you must have some experience. Without doing so, they have diluted it. They said that if you have experience, if it is a prior, if it is in a government, because they mentioned in a government or aided school, then you will get 10 marks. Does it mean it is completely choked? My answer would be no. Yes, it is reduced, competition becomes more. But that is, my lord, that is for a reason which is not unreasonable. It is not unreasonable because in judicial examination, experience has been, because fundamentally.
Tell me something, if if the issue is pending before the Supreme Court, the court will not look into it.
It is.
First, second, this issue, 10 marks. Other issues, it may be pending. The court is not concerned because that has not been placed.
We'll come back on 12.
That
But I
is
also said we'll not
the first thing that is staying in the mind.
With a full confidence, then I have to get hold of
Somebody
these.
must be there
Yes,
having
yes.
documents to show.
My lord, I say this, that this teaching experience point is not pending before the Supreme Court.
SLP.
Not the SLP, the original writ petition.
Original, nothing.
They have to bring original writ petition in which.
Yes, one is fixed on the 26th.
As well as the writ petition.
Well, what happens, that technically it might be possible that the point of when is not there, but prior experience was there, that is clear. Whether prior experience was there and that 10 marks is entitled, that is there is no doubt about it. Question is, these two things.
Why don't you all see, you all are filing so many applications, petitions and everything, get some order from the Supreme Court.
Yes.
It permits the court to look at this issue.
That's the propriety.
This is the cause of action which was available to them in the month of August.
My writ petition, my course of action was not available.
My lord, he sat for the examination keeping his eyes closed.
But the rule says that there is a possibility that the 10 months will be given at the preparation of the panel. In my challenge, whether the 10 months are to be given to 2016 capital appointee.
It is on 26 November. This is the ground.
Bench to individual issues in the advertisement, right? Whether can be looked into by the High Court when the issue is pending before the Supreme
Well, at this juncture,
just take
Even an arbiter of division bench is binding on single bench.
you please get
Even
this
even-
type of orders. I am
uh,
keeping it next week because 12th the matter is already fixed. In the meantime,
yes,
please,
on Monday.
This is the ground.
in the meantime, you try to get order from the
Please, Shadu Khan, আমি এটা দেখাচ্ছি।
High Court to get it done.
এটা
Lord,
number
no will not do.
2082 দেখাচ্ছি। আমি দেখাচ্ছি, দেখে নিন।
Nothing is pending before the Supreme Court.
My lord, Abhijit Saduka, I just now, my lord, got.
See, all different names are
The
coming.
difficulties, my lord, there are n number of matters. The only ploy of the petitioners are to come to your lordship's court at the last moment. They were of the rules, my lord. These rules were promulgated in the month of May 2025.
Somehow what they have failed to do directly, to do it indirectly to
This is
accommodate
completely beyond their pleadings.
tainted candidate.
Completely beyond their pleadings.
What do they gain out of it?
That is, the gain is to stall the process.
What do they gain?
That is the only gain.
This is unfortunate.
Now that a
This is
commission is saying such thing, my lord. That means the commission, we are not equal to the commission.
This is a with all due respect, this is a political statement.
They are also
This is not expected from a commission.
anything out of the
That
whole
shows
thing.
that commission is not treating us equally.
Stall the process. They failed.
Much shows.
Not the matter.
The results are not
Kindly
declared.
visualize.
They do not
The
know what
Supreme
their
Court has
position is.
directed us. Mr. Chatterjee produced orders. It says, my lord. Yes, please.
Abhijit Shadu Khan is
my lord, that would be the
Best
I
course
feel,
of
my lord,
action.
that would be the best course of action. We get hold of all the SLPs, copies and the orders.
Either keep
Otherwise,
it on
otherwise,
12
I'm not saying
or
lordship
earlier.
doesn't have power. I say,
And whatever y'all rely upon, please circulate with the petitioners so that they also get come prepared. Otherwise,
this is
again,
the
But I
John,
understand. I will give.
there is a timeline within which things are to be done.
Correct.
diary numberটাও আছে। Diary number
First, yes,
Instead of not,
has service of the cans been made to the commission?
I believe that this is not a application on 32 blood. That they must bring the writ petition in which it was originally challenged. Instead of the SLP. But SLP, they cannot expand the scope of the writ petition. Therefore, they have to produce the writ petition. And the second issue, we do not want to jumble it.
Keep it on 10th and Monday even.
All that today.
They cannot come prepared.
Today my simple prayer is the whatever issue pending is not so far this when at what stage this marks to be given is not pending for the Supreme Court. Now
What stage
today
to begin? That's right. That's right.
today they may publish the result or list of candidates. One line order is required from this court that whatever result they publish, that would be subject to the result of the writ petition.
We are opposing that.
Otherwise,
No, it goes without saying.
goes
Opposing the prayer.
will not prejudice anybody.
Yes,
That goes without
My lord,
saying.
even if your lordship
Lordship can
does not
always
receive-
ask.
even if your lordship does
They
not
do not see from you this type of submission. is
kindly,
not
my lord,
acceptable. No.
he is
You remember, it's all right.
he is making this submission. He is, my lord, requesting.
He
the-
is.
May I point out only one sentence? I'll hold my
ground
breath.
8 and ground 9 same.
But only one sentence apropos the interim order that is being prayed. But in the notification itself, employment notification itself, it was made clear that the participation is without intending to create any equity or right to any
Yes,
party.
it
who
goes
may
without
choose
saying.
to apply.
That is not subject
That
to
is all right. But that is the ultimate. That is the ultimate. Empanelment does not create any right. It's that type of thing.
Any thing is done today, that can be undone, number one.
Yes, yes.
Won't create any right
That is always subject to the
Yes,
result of
always,
the
always.
petition.
Yes, kindly record.
Sadhuka SLP losses, kindly have a look at the ground. Look,
8 and 9.
Kindly have a look at the
8
ground.
and
Yesterday it was not there.
No, no, yesterday it was not.
Well, let that be considered man, on 12th.
I think we should reserve our energy for
How
12.
many cans have you supplied to Mr. Bandyopadhyay?
I have also not received it. I have supplied except state.
He is appearing for the state.
State, I
Then
Even Milord, the commission has not received any application.
Wait,
Milord, the applications have also not been received by the commission.
hey, commission has not received your application.
Only can 5 I find.
Yes, the lucky one. What about your can? Please serve.
state I will give. The commission I have given.
No, commission has not got.
Have the copy of the.
One thing, all pleadings and copies should also be served upon us.
Yes.
They are ready.
Lordship may pass exactly the same order.
Yesterday that was passed earlier.
He has received all.
I cannot hear you, sir.
I'm on behalf of the intervening applicants, my lord.
Again, intervening applicant.
Yes, my lord. It is a can 4 of today's item number 2. I just want to indicate that, my lord, I am led by Dr. Maneka Guruswamy.
Yes.
She could not appear today, my lord, due to some difficulty. My lord heard yesterday the same application. I just want to indicate, yes, I just want.
Appearance 12th, it will be heard.
Yes, my lord.
যে যে মামলাগুলো আজকে শুনানি হয়েছে না ক্যান স্কুলেও নম্বরগুলো কিন্তু দেবেন। This is item numbers 2 and 3 together. Heard submission made on behalf of the petitioners, comma, the applicants, comma, the state and the school service commission. The issue relates to the recruitment notification published by the School Education Department on 29th May 2025 for selection for appointment to the post of assistant teachers in junior high, comma, secondary and higher secondary schools. Stop. Submission has been made by some of the applicants that the issue raised in the instant writ petition is pending consideration before the Honorable Supreme Court. Stop.
May use effectively pending.
The provisions of the rules, namely the West Bengal School Service Commission, bracket open, selection for appointment to the posts of assistant teachers for upper primary level of classes, bracket open, third bracket, except work education and physical education, third bracket close, comma, classes 9 and 10 and 10 and 12 and 11 and 12. Rules এর আগে bracket close, comma, 2025. Page number 79, এখানে রুলের নামটা আছে, দেখে নেবেন, ডেট আছে। Stop. The learned advocates representing the petitioners denies the submission. Stop. It has been submitted that not a single writ petition challenging the above rules is pending consideration before the Supreme Court. Stop. The paragraph, the specific issue that has been raised today is questioning the stage at which the 10 marks allocated for prior teaching experience is to be awarded. Stop. Whether the same is to be awarded prior to preparation of the interview list
Preliminary interview.
or prior to the preparation of the
Merit list.
list. Please find out whether there is any description of preliminary
Yes,
interview
yes,
list.
eight itself.
No, not 8. The definitions are there.
No.
Definition whether preliminary
The rule
list is there.
11 mentions preliminary in
Where is it described?
Rule 8.
But it is described
Sub
as
rule 8.
interview list.
Interview list.
Interview.
The
list.
sub 11.8. 11.8.
Is it prior to interview or post?
It's 11.8.
Further
Mention.
issue that has been raised
Under 11 rule 8 says, all right. It
is
mentions preliminary list.
whether not whether is the justification of leaving out the in-service teachers of private schools from the realm of consideration of the selection. Stop.
Experience of secondary division can be used in higher secondary.
The experience of using the experience of teaching students in the secondary level to be used as experience for teaching candidates, not candidates, students in the
Participant of secondary, senior secondary.
for Willem? In classes 11 and 12.
My lord, whether 2016 appointees will get those 10 marks.
Stop. It has been highlighted that if 10 marks is added to the candidates who appear for teaching in level 11 and 12 to the in-service candidates, then the freshers will never get a chance to be appointed.
Yes.
Stop.
Another point argued whether 2016 candidates will get the role.
Rationality.
It has also been questioned as to whether the examinees whose selection in the year 2016 stood null and void by the order of the Supreme Court would be entitled to the benefit of 10 marks for the prior teaching experience. Stop. That apart, paragraph, the other points have also been raised, but the broad heads are mentioned herein above.
One more, the demonstration 10 marks given at the time of preparation of merit list, and there's 10 marks for teaching experience. For the same reason, 10 marks again in demonstration. That's the rationality part I have taken.
The logic part, not the point.
To challenge that rules.
I am not going to all these. Paragraph একটা দিন, the parties are directed to exchange all pleadings and documents to be relied upon by them at the time of hearing, so that none of the parties is taken by surprise at the time of hearing. Stop. Copy of all intervening applications shall be exchanged. Stop. The parties are directed to produce documents in support of the submission that the issues framed herein above are pending consideration before the Honorable Supreme Court.
প্রথমে বলে দিয়েছেন।
The matter is fixed on the 12th of November.
That they will provide the copies.
It is served. No issues. If not served, please serve.
My lord, only
My lord.
request, my lord, your lordship has been kind enough to record the commission submission also, my lord, that the writ petition is not maintainable at this stage, my lord, the point of maintainability be kept open. We have also cited judgments. Mr. Bandyopadhyay has.
The respondents issue regarding maintainability of the writ petition is being decided by the court and it is kept open.
On the last line I have prayed for.
Last?
That I have prayed for, that result of the writ petition.
Yes, yes. It has been brought to the notice of the court that the result of the written examination is due to be published today. Stop. As the issue is pending, as certain issues with regard to the awarding of 10 marks is pending consideration before the court, the result of the examination will abide by the result of the writ petition.
Grateful.
Petitions. Everybody please come prepared. Show me documents.
They will be providing us.
I will not entertain. It will go before the Supreme Court.
I follow. They will be providing us the copies of the SLPs and writ petition.
Numbers are given. If the numbers are given, then also they can find it out.
I personally sent it to Mr. Shah.
That may be your set of documents. There are so many. Nobody is taking responsibility for the others. Take responsibility for your own self.
তুই একটা কথা জিজ্ঞেস করতো আগে আসলে বলে দিয়েছে
Assigned matter, item number 11.
By appear on behalf of the
Union of India. In this, Your Lordship, in the last occasion, the learned ASD had made submissions and Your Lordship was pleased to record. Whoever is not having the consent to operate and consent to establish and other trade licenses, the state government should take action against them. Pertaining to item 11, Your Lordship, the consent to operate pleading has been done by the petitioner at page 7, para 4, subpara 4, wherein they say that they have a consent to establish and consent to operate. Para 41, they have annexed the consent to establish, but consent to operate is not annexed. Consent to establish is also for a limited time, not unlimited time. This was
That period has expired.
This is issued in 2018, consent to establish.
right.
Normally it is for 10 years, not after that.
All right. So
And
it is still valid.
Your Lordship, corresponding for this way, page 102, the state or the PCB had submitted a report, point number 44. For this kind, it is stated that obtained CFO on 24th May 2018 from West Bengal Pollution Control Board, which was valid up to 2022. So it doesn't have a valid consent to operate. So it cannot operate.
1 minute. Whether this bench has determination to take up the issue?
Your Lordship, this is an assigned matter. It is coming under the assigned. It is coming under the heading assigned.
It is assigned to the bench having determination.
Lordship, subject to correction. That is what.
So this bench doesn't have the determination now, so it will go. Please come. The instant writ petition has been assigned to the bench having determination to take up Group 9 matters. Stop. Let the same be released from the list of this bench for want of determination and be placed before the bench having determination.
Probably.
Yes, I
The report file for it. No, bullet 11. Same order of it. Lordship, 11 to 15 probably are the.
আমার নামে কোনো অ্যাসাইনমেন্ট আছে? নেই তো, নামে অ্যাসাইন নয়, ওইভাবেই তো all will
My lord, for item numbers 12 to 15, can my lord extend the time for filing the affidavit on behalf of the union?
a bench which does not have
I understand.
jurisdiction will pass order.
I understand. We will file. Ma'am, this
Yes.
Obliged.
Obliged, my lord.
What?
I have no problem. Why not heart the matter?
We should actually get it assigned.
If something is against somebody, he will go and take this point only.
Which point?
The minor has no jurisdiction.
Obviously, the court doesn't have jurisdiction.
Point, one can recall that order.
Which order?
Someone says the aircraft flight over the Calcutta High Court has jurisdiction. My lord will be astonished. This point was not taken before Justice Sen. For the first time in the Supreme Court, this point has been taken.
Yes. To Delhi, na? From Calcutta.
17.
I'm seeking for a short passover.
State, your lordship. State. Passover. Why?
My senior is this matter is led by Mr. Firdaus Samim, my senior. He is appearing before the court number 37.
Where is he on record?
She is also.
What is your prayer? Interest on arrear pension, your lordship. Interest on arrear pension.
Finally, my lord, short passover.
it area pension or is it the CPF to GPF conversion?
No, my lord, it was refunded. Like, kindly see the prayer, my
That
lord.
means refunded means call the learned council. Yes, next pass over.
I am for the petition.
I'm for the state, my lord.
Lordship, matter relates to CPF to GPF. Lordship, your lordship's order.
Give me. Dekhi. ওনার appearance টা record করে নেবেন। Did you check up the dates and everything?
Yes, lordship.
আপনার appearance টা record হবে। দেওয়া আছে, service দেওয়া আছে। Disposed.
Grateful, my lord.
Nineteen is also same.
দেখি। None for the state.
Item number 19, your lordship. Shipra Majumdar is coming.
Yes, same. Disposed.
Much obliged. Grateful, your
Where is the council for the state? I do not see.
Here, she's coming, your lordship.
Item number 20, I am the petitioner, my lord. The matters, my lord, relate to the higher scale of pay, my lord. Matters relate to the higher scale of pay, my lord. Petitioner, before entering into the service, my lord, she took admission and completed part 1 examination and covered by the judgment, my lord. Your lordship also passed the same order.
Let me see.
N. Item number 90. Registration.
Same DI.
Same DI.
Yes, ma'am.
Right. Representation.
Presentation, my lord, page 50. 51, my lord, thereafter 54.
Where is the account?
Date of your representation 54.
54, my lord.
Oh, this is legal representation.
Yes, ma'am.
Just 1425.
Before there were 51, my lord, made by the school authority, 2017.
It is 20. Are you there? Item 20?
Item number 19.
No, 19 is all right. 20, nobody is there. None. Yes, sir. হার হবে দেখে নেবেন পারমিতা ওটা দেখে নেবেন এখন সিমিলার অর্ডার আছে তো এটা 24 হবে disposed
Madam. I am for the petition. These matters, my lord, relate to the 2 additional increment on acquiring the PhD degree, my lord. The petitioner, my lords, made representation on.
will it not be covered under the higher scale of pay?
No, no, my lord.
All right.
Page 29 is the representation. Just still pending
29 is the representation by the school.
by the school. Thereafter,
Yes.
thereafter page 35, my lord. Page 34, sorry, ma'am. Still pending before the authority.
Show me the supporting law.
For enhancement of qualification, my lord, only PhD degree.
PhD degree increment that you are entitled to?
What is the judgment delivered in 2012, my lord? Page 35. Under section 43 of the West Bengal Control Expenditure Act, there was an indication if a teacher appointed as honors postgraduate category.
Don't go to the Expenditure Act. Show me the provision according to which you are entitled to these two increments. Show me that provision.
I can make it note today, my lord.
Affidavit of service filed in court is taken on record. Stop. None represents the respondents. Stop. Let further notice be issued. Stop. Released next Friday.
My lord. Yes.
I am for the private respondent number 6.
Have you filed your Wakalatnama?
তো ফাইল করতে ওকে বলেছি বাবু ভাই
For the petition.
Yes.
The petitioner is presently the teacher in
Notice
charge.
for the state, where is your service?
I have served upon the state. My lord, the service is there, it's showing it's served, but affidavit of service is.
State?
My lord, it's state, it's GP service is here. No, it is also government of West Bengal. District inspector of the school has been served.
No, but then the GP has also
GP
been
has
served.
already served.
GP has been served.
But
Give your
private
service.
respondent is present.
Yes, give the service. Yes. What is your submission?
My lord, my submission is what has happened, my lord. I am the presently working as the teacher in charge of the school. Now, an unfortunate event happened. The president of the school managing committee one day rushed to my office, forced me to sign on a letter and give the endorsement. I said that I cannot do that. You have to wait for some time. He started to beat me. He has beaten me and thrust me out of the school premises. The premises is located adjacent to the local police Fari outpost. Now, Lordship, now presently the problem is that unless the school is appointed, an administrator is appointed in the school, it is very difficult for me to run. What is happening? Now they are forcing me, they are giving me a threat by saying that you cannot charge more than 240 rupees as the fees. But this is the rule. Normally, the fees are charged at the rate of thousands or 1200 rupees.
In government schools?
Everywhere. That is the practice.
How?
And I being the...
How are you justifying this if the rate
I cannot justify. I can only say that he is now threatening, and Lordship, this rule has to be enforced. That 240 rupees, that is the government rule that has to be enforced. And I want an inquiry on this, that how this can be done. Every time we are told that you can ask, you have to do this self-finance. Now, I am today, what I am lacking today, Lordship, I made a representation before the authority, concerned authority, but unfortunately, that representation, though it has been filed, I have the proof, but that copy of the representation has not attached. Yes, my lord. If your lordship give me a permission, I will get that by filing a supplementary affidavit. I will.
All right, please come. The petitioner seeks leave to file supplementary affidavit annexing a document which will be extremely relevant for deciding the issue in question. Stop. It has been submitted that though the subject document has been mentioned and described in the writ petition, copy thereof has been inadvertently left out. Stop. Affidavit of service is taken on record. None appears either on behalf of the school or the state respondents. Stuff. Let further notice be served upon the non-appearing respondents. Stuff. Released 18th of November.
Grateful.
Supplementary affidavit may be prepared and circulated by 12th.
Grateful.
Private respondent, in case Wakalat number is not filed, file it. It has not been filed.
The clerk has been sent to file that, my lord.
Sent to file. At a leave the other private respondent to file Wakalat number prior to the adjourned date.
Publishment.
Yes, petitioner.
Yes, Lord. What do you mean? Revised.
You want revised gratuity 2019.
Yes, sir.
All right. You were the teacher?
Yes, Lord. No, not Group D staff clerk.
Group D staff clerk.
Yes, Lord.
প্রদীপ ওই একটু দেখে নেবেন কোথাও যদি টিচার লেখা থাকে না সেখানে শুধু এমপ্লয়ি করে দেবেন, ইট উইল কভার এভরিথিং। তাহলে দেখে নিতে হবে একটুখানি। and disposed আর স্টেট নেই ভেতরেও আফটার হিয়ারিং বোথ সাইডস এর জায়গায় পিটিশনার হয়ে যাবে। 24
I'm for the state.
you are there for the state
Assistant teacher.
revised gratuity. All right. Disposed.
My lord, for state respondent.
What is it?
My lord, it's an additional marks which has been given to the selected candidate pursuant to the direction of the Honorable Supreme Court 25. My lord, they wants the additional marks should be given to the prior experience. Notification.
Is it the second SLST issue?
Yes,
Or-
my lord, that is 20
SLST.
second SLST issue.
Second SLST issue?
My lord.
None appears on behalf of the petitioner at the time of call. Release the matter on 12th.
We appeal to the commission. My lord, 12th, my lord, I have personal difficulty. My wife operate date is 12.
The
Other-
difficulty is this cannot be posted on any other date because a whole lot of matters are appearing on the 12th. Keep somebody.
My lord.
Next.
এটা ফার্স্ট পেজটার ছবি তুলে নেয়।
হ্যাঁ ডাকুন।
আমি এদিকে আসি কেন ওখানে?
This matter is regarding my lord, somebody was there. Seventeen, you are there for the state. Yes.
My lord, the petitioner was a retired teacher, my lord. She exercised option from CPF to GPF. My lord, the delayed payment interest, my lord. The earlier occasion, the petitioner has made one writ petition and my lord, page number 28.
This issue was pending consideration, isn't
No,
it?
already, my lord, decided that when the I have to, my lord, then take instruction if my lord.
What has been decided is the main refund. But then as regards interest on the delayed part was under consideration.
Then I have to check.
Please check up.
My lord, in the meantime, my lord, there is a typographical error in the.
Where?
My lord, in para 10 and 11, my lord, the amount.
Yes.
Wrongly, the amount is mentioned as 2 lakh something, my lord.
24.
2 lakh 24,216, my lord. This is not a right calculation. My lord, kindly allow me to correct this.
But this figure is repeated in the prayer also.
Yes, my lord. In para 10, 11, it is there. Ground 9 and 10, it is there. And prayer AB, it is there, my lord.
What should it be?
My lord, they will decide, my lord.
Then
After.
why do you mention the
My lord, it
calculation?
is wrongly,
Usually
my lord.
is it not mentioned?
Yes, my lord. Only allow me to correct those portion.
How can you correct it? Because you do not know the figure.
My lord, I will just delete the
You
amount.
want the amount to be deleted.
Yes, your lord.
Please come. The petitioner is a retired employee. Stuff. The instant writ petition has been filed seeking for a direction upon the respondents to pay interest on account of delayed payment of the
Pension amount.
arrear pension. Stuff. The petitioner has incorporated the figure rupees 2,24,216 in several in various paragraphs and the prayer of the writ petition, prayers of the writ petition. Stop. Learned advocate for the petitioner submits that the said figure is not proper. Stop. Prayer has been made to grant leave to delete the said figure. Stop. It has been submitted that the figure will be calculated by the respondent authorities.
May I suggest one thing?
Yes.
May I suggest one thing? There is a representation. It will be kind enough because of that. Junior wrongly, the amount is wrong. Actual, if 8% is compounded, it would figure it would be 16,48,000. So it will be kind enough. They made a representation. If they consider this representation in the light.
No, there was an issue pending before the court with regard to the interest part.
Yes.
CPF, GPF, where is the order?
That order, I believe there is no such pendency regarding interest part. I believe so. If that's so, they can raise their
in primary, when I was taking up, I remember there was.
I believe there is no such on the part of interest because
yes,
that is itself, it principally decide because interest part is it's a usufruct of principle.
No, but then are you aware?
It is not in my knowledge, my lord.
Maybe. And learned advocate representing the state respondents is directed to come ready with proper instruction.
Yes.
আচ্ছা একটা leave কি দিলাম?
Give one leave.
To delete দিয়ে. ঠিক আছে?
Delete. The amount.
Wherever it
mentioned that
appears in the writ petition. Delete টা. And how soon can you come back? Keep it on the 14th, Friday, next Friday.
Leave is granted.
Leave is granted.
Yes, leave granted. Leave is granted, so
yes.
record correct.
We'll delete that.
Delete delete কেটে দিয়ে persons of order. I just take care of it. Grateful, my lord.
Yes.
Supposed to be interest and gratuity revised with you. Assistant teacher.
Revised gratuity?
Yes, Lordship. Assistant teacher.
All right. Disposed. None for the state.
'91 is also same, my lord. Assistant headmaster. Revised gratuity.
Yes. Disposed.
Machu. 92 also same, my lord. Teacher in charge.
Put in your appearance. Disposed.
93, my lord, and rank or not.
Not today.
Petitioner, my died in harness, single PPF. Petitioner husband was an approved assistant teacher.
You want the revised part, or did you get the first one?
A single PPO, your lordship.
Single PPO. You want gratuity and arrear pension. All right. Disposed.
I'm for the petition. I'm for the petition. Revised PPO ROPA 2019, assistant teacher.
You want revised gratuity
Gratuity and area.
and arrear pension.
Yes, sir.
Yes, disposed.
Grateful.
'96.
Petitioner. ROPA 2019. Petitioner was an approved assistant teacher.
Yes, you want what?
Interest on gratuity and arrear pension.
Disposed.
And for the petitioner, my lord, same, your lordship. Revised PPO. Petitioner was an approved assistant teacher.
Revised gratuity and revised arrear pension. Yes, disposed.
Item number 98.
98, my lord, and for the petitioner, the single PPO. The interest on gratuity and arrear pension, your lordship, petitioner was an approved assistant teacher.
Dismissed on the ground of delay. Dismissed.
Item number 19.
99, 99, your lordship, and for the petition.
Yes.
Revised PPO.
Gratuity, arrear pension, both.
Gratuity and arrear pension, your petition was an gate master.
Disposed.
Number 100.
100, your lordship, I'm praying for not this week.
Not this week. Today is the last day of the week.
Yes.
Only not
Actually,
today.
Petitioner advocate on record is suffering from some health issues. That's why he is praying for 2 days, 2 weeks accommodation.
2 weeks. Accommodation has been sought for on behalf of the learned advocate representing the petitioner. Stop. I'll post it next month.
Lordship 100, 101, 102, the same issue.
List on 1st December. তা না হলে পরের বার এসে বোঝা যাবে the list.
Up to 109 বলে দাও। হ্যাঁ,
হ্যাঁ।
102 to 109 বলে দাও। Up to 107 and then your lordship 109.
1 minute. Up to 107, 105 is somebody else.
105 is somebody else.
Let it be called 111 till 114. 104, it is adjourned.
103, I am for the state.
It is adjourned. Give your appearance. It will appear next month.
100 I am suggesting.
Please give your appearance. Call 105. None for the petitioner. List on 12th. $106, not this month. 107, not this month.
Yalla, yalla.
108 I am paying for not today.
Only not today. All right, not today. 108, not today. Not today হলে সোমবার দিন লিস্টটা দিয়ে দেবেন। For this month. Adjourn for the month. And 1011 is also adjourned for the month. 1010.
I am for the
Yes.
there should be interest on gratuity revised PPF, gratuity and area interest. 1010. Revised PPF over 2019. এটা নিন এই যে এফিডেভিট অফ সার্ভিস
হ্যাঁ অর্ডার হয়েছে Yes.
Interest on gratuity and area pension revised.
Revised?
Yes, Lordship. Teacher in charge was the petition.
Disposed.
Much obliged. হ্যাঁ এই যে এটা নিয়ে নিন না এটা নিয়ে নিন
You are for the state? Give your appearance.
এই এটা নিন।
My lord, my lord, I'm only praying for not today.
Not today. The council was here just some time back, I saw.
My lord, Mr. Aturu Banerjee is appearing for the petitioner due to some medical illness just before his.
Not today.
Grateful, my lord.
না না আমার আবার বড় ম্যাটার বেশি আছে 13 I am for the petitioner.
Yes.
My lord, the petitioner seeks transfer, page 49. My lord, the page 49, her application has been sent back relying rule 5 sub rule 6, 10% of the total strength. That is the bar. My lord, the first application you also will find page 49, 13th August 2021. After 13th August 2021, she made an application 5th September because you also will find page 67, 4 teacher joined on transfer in that school. That is why she made again 6th September. But again, HY back to the applicant that rule 5 sub rule 6. I have annexed the rule 5 sub rule 6, my lord, 10% out of total strength cannot be.
Who is for the state?
My lord, that was previously heard, and my lord, previous bench was pleased to direct, my lord, I have also served upon the government pleader, my lord, the previous government pleader himself. Yes, you'll also kindly see the notice. I have served upon them. Page 67, you also will find serial number 17. He joined on 4th September. After my first application, serial number 30, she joined on 4th January.
Which page?
Page 67.
Serial number 20.
Serial number first 17.
17.
17 joined 4th September 2021. 4th September before my application, 5th September. Next, page serial number 45, he joined on 9th February.
This was on 21, we are in 25, end of 25. Whether the staff strength is same or not, nobody knows.
No, 21.
We are in 25. The staff strength, is it same?
Challenge was, my lord,
I understand the challenge was then, but today what is the staff strength? You do not know. Who is for the state?
But the question is, my lord, on the last application, 5th September, that was returned by the head of HOI, head of the institution. That is wrong because prior to that application,
assuming that is wrong.
Today I don't know, my lord, what is the staff pattern.
Right. You filed the writ petition in 2025 challenging the rejection of 2021. You filed fresh application.
No.
Why not?
You also know, my lord, the suspension, portal of suspension of portal, my lord.
It is not a matter of suspension of portal. It is a matter of the staff strength that is there.
No, my lord, it appears from the staff pattern, even assuming that after that, my lord, some teachers, my lord,
may have left.
But my applications cannot be hampered because my applications was returned back due to wrong conception.
Any idea about
regarding the pupil teacher ratio? If you that has to be ascertained by the laboratory.
Pupil teacher ratio, staff pattern.
You can also it is not the people teacher ratio, it is a staff pattern that has been checked up by the DI. So the state is not represented.
At least school can say, my lord, what is the representative.
School can say, the DI can also take information from the school. At least I need. You can also take information from the. Please. আসুন তো দেখি
পারবে না, my lord, you also I tell you also, my lord, direct the DI to file a report. I can communicate, my lord, DI ছাড়া তুমি কি করে এসএসসি কি করে?
The application of the petitioner seeking transfer on distance ground stood rejected by the school authority, by the head of the institution twice on the ground that the same infringes Rule 5 within bracket 6 of the notification number, page 49 है, আছে একটু লিখে নেবেন।
Very transfer rules.
ঠিক
Good,
আছে?
transfer rules. That is 11 months transfer.
Stop.
That is, I have
None appears
page
on
51.
behalf of the school authority or the state respondents. Stop. Let further notice be issued upon the non-appearing respondents, intimating that the matter will appear in the list on 21st November. Stop. Learned advocate representing the state respondents shall obtain a report from the district inspector of schools. Which place? Not 24 Parganas.
That is,
It's not 24 Parganas, isn't it?
yes, yes. Not
Uh,
24 Parganas.
Not 24 Parganas. Regarding the staff strength of the subject school. Stop. Learned advocate representing the commission is also directed to obtain necessary instruction with regard to the staff strength of the school from where the petitioner seeks transfer. Stop. Let this order be communicated to the learned advocate representing the state, the non-appearing respondents. Acha. Letter dated 24th September 2025 by the learned advocate for the petitioner, addressed to the learned advocates representing the state respondents. Handed over in court today, be written with the records. Next. Fortnight, 2 weeks.
114, my lord, I am for the petitioner. Here in the instant case, Lordship kindly have a look into the
Wakalatnama filed?
not really, my lord.
Wait, please wait.
Not required.
Please wait. Yes.
My lord, this is my supplementary affidavit. My lord, Lordship kindly have a look into the last order passed by Justice Bhattacharya.
24th September?
My lord,
In spite of notice, none appears for the
thereafter,
West Bengal board is directed to serve notice. There is
my lord,
nothing.
my lord, thereafter, my lord,
Thereafter, this is the last order.
my lord, previous order, my lord,
Previous, or give me the date.
my lord,
21st April.
my lord,
A report by the DI, it appears that on the gravity of the allegations made against the petition issued. Who's appearing for the board?
my lord, what has happened in this case, my lord, the from month of January 2025, petitioner salary was stopped. My lord, and no proceeding, nothing, my lord. My lord, petitioner not suspended. Kindly have a look into my supplementary evidence.
Did you get a copy?
My lord, already. My lord, supplementary evidence, my lord, page 4, chart sheet.
What has been appointed? Presenting officer, disciplinary proceeding, that means initiated.
Chart sheet has my lordship, but
Any criminal proceeding?
no, no criminal proceeding. It's not only that, my lord, before that, what has happened? From January 2025, petitioner salary was stopped. Prior to that,
Are you still attending the school?
my lord, what has happened? Petitioner was restrained to, my lord, restrained to resume his duty in the school, my lord, by the local hooligans. My lord, I have made it, please allow
I
me.
will not hear you. You are not a party.
My lord,
You are not So what? What he is complaining, I'll hear him. In case you want to be added as a party, make application. Why will the court hear somebody who's not a party? I'll see whoever you are.
23, my lord, I made a representation to the Secretary, School Education Department, prayer for taking step to get entry into school and consider leave of absence as on duty. From 18 July 2024, my lord, I made a first representation, my lord, in the year July 2024. Thereafter, kindly have a look into page 25.
But then school education department doesn't have any power to regularize your leave.
My lord, kindly have a look into page 25. To the President, জয় কৃষ্ণপুর হাই স্কুল, আপনার বিদ্যালয়ের প্রাক্তন ভারপ্রাপ্ত প্রধান শিক্ষক বর্তমান সহকারী শিক্ষক, আপনার অবগতির জন্য জানাই যে বিদ্যালয়ের বর্তমান ভারপ্রাপ্ত প্রধান শিক্ষিকা শাশ্বতী কোলে মহাশয় কয়েকজন ব্যক্তির সাহায্য নিয়ে দীর্ঘদিন ধরে আমাকে কাজে যোগদানে বাধা দিচ্ছেন। আমার অনিচ্ছাকৃত অনুপস্থিতির দিনগুলি যাতে অন ডিউটি হিসেবে বিবেচিত হয় এবং আমি যাতে কাজে যোগদান করার দায়িত্ব এবং কর্তব্য পালন করতে পারি তার জন্য অবিলম্বে যথাযথ ব্যবস্থা গ্রহণের অনুরোধ করছি। Thereafter, kindly come to Lordship, page 27. আমি প্রশান্ত কুমার সানিগ্রাহী সাচানসাদ বিদ্যালয়ের ভারপ্রাপ্ত প্রধান শিক্ষিকা শাশ্বতী কোলে মহাশয়, অংশুমান মণ্ডল, তরুণ কুমার পরামানিক, তরুণ কুমার ঘোষ সহ কয়েকজন বহিরাগত ব্যক্তি এবং বিদ্যালয়ের কম্পিউটার প্রশিক্ষক সঞ্জিত কুমার ঘোষের সহযোগিতায় আমাকে দীর্ঘদিন ধরে কাজে যোগদানে বাধা দিচ্ছেন। পরীক্ষার প্রশ্নপত্র তৈরি, খাতা দেখা, পোর্টালে নম্বর তোলা, একাধিক গুরুত্বপূর্ণ কাজ সম্পাদন করা এবং দিনের পর দিন বিদ্যালয়ে গেলেও তিনি আমাকে হাজিরা খাতায় স্বাক্ষর করতে।
No, it is all right. This
one after, my lord, hereafter,
you are there.
What, my lord, why they, my lord, resisted me to enter into the school? There is a cause. That cause, my lord, kindly come to page 34 onwards. My lord, one Subhash Chandra Ghosh, one of the, my lord, erstwhile headmaster, after retirement, and that time I was the teacher in charge. And thereafter, what has happened, that Subhash Chandra Ghosh, my lord,
think it's Hilo.
Subhash Chandra Ghosh filed a writ petition before this honorable court, page 34 onwards, my lord, one after another, my lord, order. That time I was the teacher in charge. And that pension paper, my lord, totally irregular pension paper. And for that reason, my lord, that time, that petition, I was the private respondent. And Honorable Justice Biswajit Basu, my lord, kindly have a look into page 34 onward. My lord, one after another order was passed. Thereafter, that was regularized and pension was disbursed, my lord. And I, my lord, resigned from the teacher in charge. Resigned from the teacher in charge. That Subhash Chandra Ghosh is a, my lord, resident of that area. And with the help of the local hooligan, my lord, petitioner was resisted, and one after another, my lord, no criminal case, one after another, my lord, petitioner was heckled by the local hooligan, my lord. Kindly come to page 34, 36, 37 also. My lord, 37, Mr. Chattopadhyay filed photocopy of the
Tell me one thing, whether salary is being credited in your name to the treasury officer?
No.
To the treasury officer, how do you know?
No, my lord, salary.
You may not get it, but then on your name.
No, my lord, if you instruction and submit.
Who has stopped it?
My lord, committed by the school. The school, my lord, raised salary every
The
month,
school
my lord.
did not raise bills.
Nothing. My lord, not only that, my lord, today with due respect, I'm submitting, kindly come to page 34 onward, my lord, who appeared, sorry, I am not saying that type of, my lord, submission, my lord, totally, my lord, conspiracy of erstwhile headmaster and my lord, now school authority. And for that reason, my lord, kindly have a look into the supplementary affidavit. My lord, no suspension, nothing. Kindly have a look into page 4, No.
All right, did you give any representation to the DI?
Yes, my
Reg.
lord, after charge sheet I file my lord object, my lord, so kindly have a look into page 8, explanation in the charge issued by me, by you, by such and such, page 8, my lord, to the Deputy Secretary Disciplinary Authority.
Yes.
Page 8.
This is to the board.
No. No,
All right, take a decision. The board will take a decision with regard to the disciplinary proceeding.
No, my lord, but not suspended till now. And your lordship, explanation to show cause notice, page 18.
Where is your representation before the DI seeking release of
Yes,
salary?
that is, my lord. My lord, the page 27 to the DDO, SI. Page 27. That is in the month of
Please come.
February, but that is maybe in the month of February, my lord.
No, I won't hear you. I will not hear you. What is your submission?
SI বর্তমানে এটা হবে নাকি দেখি সেলাই করে
No, but then resignation from the post of the teacher in charge. He is there in service. Very And the petitioner claims that he was serving as a teacher in charge of the subject school stuff. Thereafter, on reporting of an untoward incident against him, the petitioner was issued a show cause notice by the West Bengal Board of Secondary Education. A disciplinary proceeding against him is pending consideration till date. Charge sheet has been served and the petitioner has replied to the same. Next. The grievance of the petitioner is that his salary since January 2025 has not been dispersed. Stop now. Even though he has not been suspended from service. It has been alleged that the petitioner is being restrained from entering into the school premises for discharging his official duties. Paragraph. Prayer has been made to direct the respondent to release his salary. Paragraph. Learned advocate representing the board submits that the proceeding before the board is pending consideration. Learned advocate representing the school submits upon instruction that the petitioner is yet to hand over charge of the post of teacher in charge. The petitioner has taken away all vital documents of the school with him and is not returning the same. Not return the same despite requests being made. Next. None represents the state respondents. Paragraph. As it appears that the petitioner is still in service, accordingly, the prayer made by the petitioner for releasing his salary, which is pending consideration, is required to be considered in accordance with law. Stop. The instant writ petition stands disposed of by directing the concerned sub-inspector of schools, being the drawing and disbursement officer, being the respondent number 6 herein, is directed to consider and dispose of the petitioner's representation dated 5th February 2025.
For 1 month only.
Acha.
Only 1 month, that time.
And-
1 month. But case 28, my lord, onward. The TIA.
Acha. Page 20, acha, dated বললাম তো 5th February 2025. For the month of January 2025 and also for the subsequent months. ঠিক আছে? An opportunity of hearing shall be granted by the aforesaid respondent to all the necessary parties prior to taking a decision in the matter. Stop. Next. As regards the proceeding that is pending before the... Did you pray for any direction? No, then why will the court go into this? কি কেটে দেবেন? না, ওই লাইনটা কেটে দিন। The petitioner has also prayed for a direction upon the respondent authorities to permit him to resume his duties. Stop. The sub-inspector of schools, at the time of hearing the parties, shall also take a decision. There is no such prayer.
Continue the salary, my lord, there be directing the rest of them, continue the salary with what is service.
Continue the salary. So regarding service, nothing. Last year এটা তাহলে দেবেন না. Disposed of. Disposed of. Time টা দিয়ে দিন. Steps shall be taken in the matter at the earliest, but positively within a period of 8 weeks from the date of communication of this order. If the petitioner's claim is admitted by the authority, comma, admitted na allowed korun, then necessary consequential steps shall be taken in accordance with law. Acha, supplementary affidavit filed by the petitioner in court today is taken on record. কি করতে হবে? কিসের ক্লাস? ও I have mentioned all necessary parties. $20. Today's list. স্টেটে ওনার নামটা নিয়ে নেবেন তো।